But in the stamp here, it is
Just
written, reported.
This one, no.
Oh, okay, it's fine. It's fine now.
What is the case number then?
Case number is A 968 of 2014.
It is on case on Safely, reported as Langer and others versus S 2017 ZAGPHHC 45. Judgment delivered on the 10th of February 2017.
Yes, written again on the face of the case.
Okay. All right, which paragraph do you want to take me to?
I rise to take the court to paragraph 8 of the case.
Okay, I'm there.
I will read it into the record.
No, which part of paragraph 8 do you want to refer me?
Starting from where paragraph 8 is starting,
It
my
is
lord.
right.
Yes.
You strike that the confession means an unequivocal acknowledgement of guilt, the equivalent of a plea of guilty before a court of law, with reference to Becker. Is that, so what part of that paragraph is important for our case?
Where there is doubt, it ultimately becomes the duty of the court to determine first the nature of the statement the state seeks to rely upon, and the objections raised in order to determine whether it is necessary to hold a trial within a trial. This is the point I raised yesterday, my lord, that it is trapped before a trial.
No. The nature of the statement. But what does that entail?
That entails the state comes and say this is a confession. Defense is saying no, this is not a confession. It is the duty of the court then.
Where does it say there? And not that I'm bound to that decision in any event, but where does it say in that judgment that I must have a judicial peek or look at the statement? That's the submission you made yesterday. I've never heard of that. Now, I haven't looked at this case, but of course the well-known case of Nkosi, that's where this is drawn from. Now you can go and look at the case, because I'm sure if you read this case last night, you would have noticed that this judge also referred to Nkosi.
Nkosi is the sixth page of the case, my lord.
That's the 1983 SA case.
That's correct, my lord. I will read the last paragraph on page 6 of this case.
On page 6 of where? You see, in this case that you took me to, the reference is made to what a confession is. And that's with reference to Rex versus Becker, the old 1929 case. Then the judge says, where there is doubt, it ultimately becomes the duty of the court to determine first the nature of the statement the state seeks to rely upon and the objection raised in order to determine whether it's necessary to hold a trial within a trial. That's also trapped. And then the judge quotes from Nkosi. And this is also a well-known quote from Nkosi. And the statement made in the main paragraph comes from the last sentence of that quote, if one wants to quote out of context, as I became used to in this trial. Because if you take it from where it starts, it seems to me, you can see that the duty rests on the parties to determine and advise the court as to what it is. And the duty is on the state first that want to present the statement to determine. And as I've indicated to you yesterday, in our case there was a dispute what it was. So then you take the safe route, you isolate, you do a trial with a trial. So that duty can't be read independently, the duty of the court. Then Botha AJS then was, said, ultimately, however, whether or not counsel for the state follows the correct procedure, it remains the overriding duty of the trial judge to satisfy himself that an admission was properly established to have been admissible in evidence. Now that's the process of the trial within a trial. It's got nothing to do with looking at statements before reliance is placed upon it in convicting the accused. That means after the evidence was admitted as evidence, because you can't rely on evidence that was not admitted, or as I've been asked in this case, counsel's thoughts on the matter.
With due respect, my lord?
Well, this case doesn't support the submission you made yesterday. So let's move on. The submission you made yesterday was that I should have looked at those statements to determine what they are.
That was the second submission, my lord. The first submission was the judicial officer has a duty to determine the statements.
Well, I hear your submission and I don't agree with it.
I would stand with what is said in the case of Langa. The
Yeah.
second leg of that, when the court asked the defense, how do I determine the nature of the statement? The answer is simple, my lord. By distinction between admission and a confession. A confession is an unequivocal
You don't have to repeat that, that's right.
acknowledgement
The
of
question is, how do I determine? If you say it's my duty, how do I determine?
Likwareni answers the court that question.
I'm sorry?
The case of Likwareni answers the court.
The case of what?
I'll give the court the full citation.
Okay, give me the case.
The state
Yeah?
and Likwareni is L-E
Uh-huh.
K H W A R E N I. The first name is Tifolu Fairly Sentry. Can I spell the first name?
Just a moment.
It's Gauteng Local Division in
Wait,
Johannesburg,
wait,
my
wait.
lord.
I'm just going to say the S, and I should be able to pick it up. That where the case number was SS 73 of 2015.
That's correct, my lord.
So let's go there.
And the judgment was delivered on the 16th of May.
16th of May 2016,
2016.
By Spilk J. There's admissibility of the statement. This was a ruling on a statement of Rambani Makuva. Although the first accused in the matter was Lekwareni. Okay, so which paragraph do you want to take me to?
It's paragraph 4, my lord.
Paragraph 4 of the judgment. So, what does that mean? I can see it. What does it mean?
My lord, it means exactly what I said yesterday. Yesterday,
Does this support your submission?
It
Okay,
is.
read it out loud. Because the prosecutor, I
it
take it, haven't seen this
is, my lord.
authority. Are you also opening the authorities as we go along?
No, unfortunately, I do not have that facilities, my lord. So no, I have not seen the case. We were not referred to.
Okay. So read it out loud so that your opponents can hear whether what you're submitting supports your proposition.
A court cannot be bound by the view of the litigants as to whether the contents of a statement amount to a confession, an admission, or something else. What follows? In the present case, in this case, it was unnecessary to have sight of the statement since both parties agreed that the statement was exculpatory. If they agreed, that is the difference to the facts in this case. If they agreed,
No, complete the quote.
okay, but according to the state, comma, contained an alibi defense which differed to that put by the accused counsel to the state's witnesses.
So what's the relevance of that case to our situation?
It is
This has got nothing to do with admissions or a confession. Here it seems how the judge came to that conclusion, I don't know because it's not motivated. But here it was an exculpatory statement, and the dispute was whether it raises an alibi or not, and whether that confirms the propositions put to the witnesses by counsel. So what the state seems, and I haven't read the case, and I don't think it's necessary for me to read the case, because if that's what you want to refer me to, I don't know why you're wasting my time with it.
Would you
Here the state wanted to attack the credibility, it seems, of the accused ultimately, by proving an extracurrial statement. So cross-examination must have taken place. Counsel puts a version to the state witness. Prosecutor sits with a statement of that accused in the docket that raises a different defense as what's now been put. It's totally different.
My lord?
What we're dealing with in this case, and what we dealt with at the trial, was it was either Section 219 situation, in other words, admissions to certain actions that could satisfy the elements of the offense charge. Alternatively, Section 217 of the Criminal Procedure Act that deals with an unequivocal admission of guilt that amounts to a plea of guilty, which is commonly called a confession. Neither of those are exculpatory, as was the case before Spiltje, it seems. And this is not a full judgment, it's an interlocutory ruling that is being made. So, and you will see, if you scroll further, and I'm just having a cursory look at, again, we're going to Becker and the definition. and then 219A is quoted. Long hearsay and. But it's easy to find paragraphs on the internet about what is applicable in certain cases. It's clear this dictum that is being relied upon does not support the proposition that we're dealing with here. The proposition we're dealing with here is you telling me that I heard, and therefore you have a reasonable prospect of success, that another court might find differently by not looking at the statements before I have the inquiry for admissibility. Now, that is so far-fetched. It has no merit. I've never heard it before, but I'm open to surprises, even at my age.
With due respect, my lord, I will stick with my submission.
Okay. You're welcome to stick with it.
Especially this paragraph is dealing with confessions
I've seen it,
and
thank you.
admissions. Still on the same case, my lord, I will take the court to page 5.
Page 5, which paragraph? Which paragraph? Because
The second
remember, I don't
paragraph.
have page numbers.
Okay. The second paragraph, my lord.
Second paragraph of. Are we still on the spoke judgment?
That's correct, my lord.
Okay. Second paragraph, the prosecution argument. Talking about that. I don't have page numbers, but this judgment has paragraph numbers. So if you can give me the paragraph number, then I will get it. Which paragraph of the judgment are we talking about?
It's paragraph 7. It will be paragraph 10, but paragraph 10 starts from page 4.
Is that the one that starts with, in my view, Rex versus Valacha?
That's not the one, my lord. It is the one that is saying, see also State versus Mhlongo. I don't know whether we're on the same page.
Well, that can't be the beginning of a paragraph. If it says see also, that's not the beginning of the paragraph. It's part of paragraph 10, right? So that's where the court says, and I'm after footnote 4, you will have a footnote 4. The way I open all these footnotes are hyperlinked. So it reads, the distinction between an admission and exculpatory statement was also made by Groskopf J.A. in State versus Kluter 1994, 1 SACR 420A at 425 CE. See also Mhlongo. Now, and then it says S versus Nkosi, 2015 2 SACR 323 CC at paragraph 33, where the court said, and then it gives the distinction between.
I'll argue this case.
What case?
In this line, that there are safeguards that a judicial
you took me to paragraph 10. Now tell me, why do you quote paragraph 10 to me? Because as I was reading that part, I was also looking at the rest of the paragraph. I read that part aloud to you, but I've also read the rest of the paragraph.
My lord?
And it doesn't support your proposition.
My lord, I said the case I'm going to refer this case to, it starts from paragraph 10.
Okay.
On my page, starting from paragraph 10, but it's not reading from paragraph 10. It is C also. I made a mention that in this paragraph 10, you must go to C also.
No,
that is the last part.
Also, and there's no, I don't know whether that S versus Mshlongo and S versus Nkosi, yeah, it was the, there were two cases that served at the same time, so that's why it's like that. And it was in the Constitutional Court, and it was determined on the 25th of June 2015, because I told you it's hyperlinked on my system. So I can open that case of Mshlongo and Nkosi. So it was argued on the 10th of March 2015. The order was given on the 25th of March 2015, and the reasons were given on the 25th of June 2015. And there were two cases that served before the court at the same time. And do you know what the Constitutional Court said in Mshlongo? You told me I must look at that judgment and see Mshlongo. Now we're looking at Mshlongo. What did the Constitutional Court say in Mshlongo? Tell me.
Say that.
I told you when the case was heard, and I take it you've read the case before you refer me to it. So what did the Constitutional Court say?
Mshlongo, because that court is saying the courts have to adhere to the safeguards
Okay, so
when they are.
so which paragraph of the Constitutional Court judgment?
My lord?
Which paragraph of the Constitutional Court judgment are you referring to?
The court has just asked me, what is the Constitutional Court saying in
Yeah.
Mshlongo?
Yes.
At the present, I don't have the case of Mshlongo. I'm having the case of Langa.
No, no, no. You see, you took me to the other case. Took me to paragraph 10. And you say I must there see Mshlongo. So now we see Mshlongo. Now I want to know, what did the Constitutional Court say in Mshlongo that is put up now to
My lord?
support your proposition? Did you read Mshlongo?
My lord, if you can.
I'm asking you, did you read Mshlongo?
There was no
Mr.
need
Gabas?
for me to read Mshlongo, because
Right.
I'm not making
So
reference
please-
to Mshlongo. I'm making
please-
reference to State versus Ngozi. It's Mshlongo. It's two cases that are mentioned in this paragraph.
Yeah.
Mshlongo, there's not even a
Okay.
title for Mshlongo.
So-
the title that is there is for S versus Ngozi,
Okay.
2015, subsection volume 2, SACR, page 323, and paragraph 33.
Paragraph
This
33.
paragraph that I read
So
is
it's
coming
a-
from Ngozi, my lord, not from Mshlongo.
Mshlongo and Nkosi is the same case.
I focus myself on the matter of Ngozi,
Okay,
paragraph
so
33
paragraph
of Ngozi.
33. The distinction between.
That's correct, my lord.
That's how it starts, right? Okay, so where will I find a dictum by the Constitutional Court that supports your proposition?
My lord, Ngozi is the matter that is being referenced to. The main matter here is Likwareni. Ngozi is mentioned in support of Likwareni. I do have the whole case of Likwareni in front of me.
No, no, I'm talking about Nkosi. You said to me I mustn't refer to it as Mshlongo, and I'm telling you it's the same case. There were two cases that served the Constitutional Court simultaneously. The one was Mshlongo, the other one was Nkosi. It's one judgment. I'm looking at paragraph 33 of that case, the Constitutional Court judgment. Now, I want to ask you, what in that paragraph 33 supports your proposition?
The last paragraph of the last two sentences of this paragraph supports my submission strongly. There must be safeguards before a trial within a trial is started.
Where do you see that? In paragraph 33.
This distinction becomes relevant in determining the safeguards that are put in place to ensure the voluntariness of the confession or admission.
Yeah. What was the Constitutional Court dealing with there? What was the question to be answered?
Admissibility.
No. Are you sure?
Admissibility and assessment.
Where do you get that from? In the judgment?
My Lord, I read the case through.
No, but wait. You see, if the precedent is set, and it will be binding on all courts by the Constitutional Court, but we look at what was the question to be answered. Then you look at the ratio. So the question here, if you go up on that page, it might be on a different page on the printed form, just above paragraph 32. The court gives a heading to that section of the judgment. And if you then read paragraph 32, you can see what it is about. Because it reads, it was contended by the applicants that the distinction drawn by Ndlovu, now we know that Ndlovu dealt with where the statement of one accused used against another, and then there was a distinction between confessions where the law was clear. Confessions can't be used against another person unless the content is repeated under oath by the co-accused. And we've made that point in this case as well. But it's trite, you don't have to cite cases for it. So confessions couldn't be used, the law was clear on that. But there was a school of thought and judgments where admissions were used. So the court says it was contended by the applicants that the distinction drawn by Ndlovu between admissions and confessions effectively leads to indirect differential treatment between different groups of accused. Those implicated by an admission on the one hand and a confession on the other. A confession is inadmissible against another person, while, according to Ndlovu, an admission may be admissible. The point I just explained. The applicants maintain that the distinction is unjustifiable, rigid, and arbitrary. It violates Section 9(1) of the Constitution, which provides that everyone is equal before the law and entitled to equal protection and benefit of the law. Then 33 deals with that distinction. The court says, per Thron AJ as she then was, the distinction between confessions and admissions is determined solely by the extent to which the statement implicates its maker. This distinction becomes relevant in determining the safeguards that are put in place to ensure the voluntariness of the confessions or admission. That's what it relates to. Not looking at paper before you determine admissibility. Do you want to quote further out of this case before I close it? Because I've got so many layers now behind with all the cases which all were irrelevant to the discussion.
With respect, my lord, the cases I quoted, they are very relevant.
To yourself, Ms. Nkaba.
Yes, my lord. My first submission before this one, to answer how does the court or a judicial officer determine the nature of the statement, whether
Well, we've been there since yesterday. And I'm saying to you, give me authority that a court must look at a document and then determine this is a confession or an admission, and then look at admissibility. So you first look at the document and then you determine its admissibility.
My lord, I will remain on my two answers on that. There's two answers to that.
Give me authority for that proposition.
I've given you the authority.
You've given me nothing.
If the court ignores
You've given me authorities that is not applicable to the submission you make.
my lord, both authorities that are given to the court, they are applicable
It's not.
to my submissions.
Now it's not, so I'm not gonna, if you can't give me anything else, move on to the next point.
As far as the ground I've mentioned, my lord, that the court has failed to determine the nature of the statements prior to
You've done that, you don't
Trial
have
within a
to.
trial.
You've done that, Ms. Nkabai, you don't have to repeat yourself.
And second leg is, after the trial, within the trial was concluded, the court failed to make a ruling whether the evidence that it admitted amounted to an admission or a confession. With respect, my lord,
So give me authority.
with the,
Give me authority that says I was obliged to say what the nature of it was. Give me authority.
my humble submission is,
Give me authority for the submission. Do you have any authority
yes,
for that
I
submission?
do. I've already given the court.
Which one?
The ones the court is saying they are not.
Well, this was about peeking, taking a peek, and it was irrelevant. Where does it say in any of these judgments that I must pronounce whether it's a confession or merely an admission?
I don't know that the court wants me to read it again.
Yeah, no. Take me to the paragraphs. In which case do you want to take me to? Which case do you want to go to? I've got them all here since Rex versus Collins of the Canadian Supreme Court.
I've already given the court
Which case?
Langa.
Langa.
I've already
Okay, let's go to
made
Langa.
reference.
No, let's go to Langa. Where in Langa does it say I must pronounce?
Paragraph 8. my lord.
Paragraph 8. Okay. Where do you see that in paragraph 8?
It becomes the duty of the court
Yeah. When? You've told me earlier on that supports the proposition that becomes my duty before we go into the trial within the trial. We are now at the stage after the trial within the trial. It can't be support for the same submission because there are two different stages.
Oh, I understand the court now.
Give me authority to say that after I've heard the evidence in the trial within a trial and given a ruling on admissibility, that I must declare what the nature of that statement is.
Yes.
In other words, whether it's a confession or mere admissions. Where is authority for that proposition? because it will also be news to my ears.
My lord, it is trite law.
Where? Give me the authority. If it's trite law, give me the authority.
I'll give the court the authority.
Thank you. I'm listening. Give me the authority for that proposition. Any authority, but don't give me magistrates' courts authority. If it's a high court, it's fine. Preferably Supreme Court of Appeal and Constitutional Court, because I'll be bound, and I will gladly admit I'm wrong. Just give me the authority.
I'll give the court that authority.
You say it's right, now give it to me. Why must I drag it out of you?
I will do, my lord,
Yes, now. I'm waiting.
during break.
What?
During break,
No, I want it now.
I don't need now.
You're telling me it's right.
It is trite law,
So
my lord.
give me the authority.
I might not have the authority now, but that doesn't mean that is not law. I know. I'll give the court authority to that effect.
It's 9:38. You hope to be on your feet still till the break time.
Yes.
You've taken a few hours yesterday and you still said nothing up till now.
How can the court?
I'm telling you that because we in argument now. This is not dealing with witnesses. I'm engaging counsel on argument. And normally, argument is even more robust. I've been patient. But I'm not going to allow counsel to make propositions on the law without giving me the authority and then telling me it's trite. So if it's so trite, it must be at your fingertips. And in today's day and age, it's a quick press of a button. You don't even have to use Copilot or ChatGPT or whatever they call those things. You can just type in and you'll get a quick rundown. But I'm not going to do the research for counsel either. And I'm not going to go and search in the dark where I know there are no ghosts. But carry on, move on to the next proposition.
Oh, move on to
Move on to the next point.
what the court.
Move on to the next point, and if you run out of your points, we'll proceed with the argument, and then I'm sure Ms. Swanepoel, them, the time now, hopefully we can finish by tea time. But if we go and we take a break, you can go and find the authority and you can give it to me in reply.
Yesterday, the court made mention of the following: that my client's testimony was bad during trial within a trial.
And I think I added, to put it lightly, he was terrible as a witness.
My submission to that, his testimony was not bad, as the court is saying, more than the testimony of the 284. It was not bad more than the police brutality. My submission will be twofold. It will start with the section 24, and then...
No, I don't want you to make comparisons. Tell me why you say your client's evidence should have been accepted in the trial within the trial.
Thank you, my lord. I will take the
And
court.
only where I erred, right? Because I'm not going to have re-argument of the main case. Remember what we're here for. We are not here to retry the case. We are here for me to determine whether there is a reasonable prospect of success that the applicants will have on appeal, that another court will come to a different conclusion. A reasonable prospect. And I'm not even going to go to the preconditions for that I've debated with Mr. Arendse yesterday on Section 17 of the Superior Courts Act.
The court erred in threatening my client.
In threatening him.
Threatening him.
Okay.
While he was giving evidence during trial, within a trial.
So
how did the court threaten?
Just a moment. Let's just pause by your submission that I threatened your client. What would have been your cause if that happened in your presence as his legal representative?
My Lord, I haven't finished my submission.
No. Let's just stop right there. Should you then not have asked for a special entry? If it happened, of course.
I did.
When? I invited you on more than one occasion
When
to file a special entry in terms of Section 317. You didn't do that.
I didn't hear the court. I thought he was saying something
No,
else.
no, no.
I didn't hear. No, I
I
didn't file
stopped you
any.
in your tracks when you said, I threatened your client. Now, we'll go into the threats now, but I'm asking you, if that happened, you should have asked for a special entry. On other occasions where I stopped you, as I'm almost on the verge of stopping you now because you're wasting my time, to make a special entry if you're not satisfied with my rulings. I invited you. You didn't do that. Now you come, and I don't know whether you're playing for the gallery, and you say, I threatened your client. But you didn't make a special entry. Is that correct?
It's correct, I didn't.
Okay, so in which manner did I threaten your client?
Thank you, my Lord. When he was giving evidence, the court continuously told my client that Miss Swanepoel will make a field out of you. Miss Swanepoel will make a field out of you. It is on the record, my Lord.
Whilst he was giving evidence.
That's correct.
In chief. In chief.
Not only that.
In chief.
Yes, my Lord. Well, I was busy cross-examining him.
When you were cross-examining?
The court was interjecting.
When you were cross-examining?
Yes. Threatening him. Miss Swanepoel will make a field out of you.
I'm not sure that you're correct on what you're saying, but let's accept the submissions. I told you yesterday, you must be careful of twisting the facts. Because remember, Ms. Swanepoel, I was surprised when Ms. Swanepoel was cross-examining your client. I didn't even know Ms. Swanepoel was going to cross-examine your client. So I know you're twisting the facts as you stand there. And it's incumbent upon counsel to honestly present the facts when they argue.
The court erred in making those remarks.
I did not say Ms. Swanepoel was going to wipe the floor with your client. And yes, unfortunately, we don't have a transcript in evidence in chief, because Ms. Swanepoel, you will recall, was not there for a number of days. Ms. Herman was dealing with a trial within a trial at the outset. I actually showed on the record my surprise when she stood up to cross-examine your client, because Ms. Herman was wiping the floor with Mr. Arms's client, to put it lightly.
On that,
The question about wiping the floor came in much later, where I made the statement that I was not surprised, and it actually found its way to the judgment. Those words, that I was not surprised when the accused elected not to testify in the main trial. That's where the wiping of the floor comes in.
my Lord, with due respect,
So please, Mr. Kabay, do not make submissions on facts. That is not true.
with due respect, my Lord, these comments were true, and they came at different stages. The first one was when I was leading my client, trial within a trial, when the court kept on saying to my client, Ms. Swanepoel will make a field out of you. The one the court that has just mentioned now, indeed, it was when we elected the right to remain silent. Then the court remarked, the reason why...
I didn't make that remark then. When we were arguing on the merits, that's when it raised its head the first time.
But what I know...
Because when the defense closed their case, all we did was to manage the argument. And it was in argument that I also questioned counsel, as we are going now. But we're not going to re-argue the case.
I'm not...
So you're saying I was biased? I threatened your client by saying that to him, as you allege.
Yes, ma'am.
Good.
Number 3, going to section 174. Humbly submit that there is a prospect of success in appeal, because the court erred in instructing Ms. Swanepoel not to respond to accused number 2's application in terms of section 174.
Yes, I did. Just a moment. I did cut the state short because there was no merit in your application. Why must I waste time? Are you saying a court must hear? Because if I erred in that sense, you say, because I didn't hear them. A court must hear the other side where non-existent points are raised by the opponent. We do that every day. I regularly sit in this courtroom on a Friday when we have appeals. And in most of the appeals that we sit in, we would normally say either to the appellant or the respondent, there's no need to hear you. Now, I'm saying to you now, if you can give me authority that the court is obliged to hear a response to a nonsensical argument, then I will admit I'm wrong. They'll grant you leave easily, but show me the authority.
My first response to that, my Lord, number 1, my argument was not nonsensical.
You asked me to accept his evidence on credibility.
It
And
was-
everybody could see it, that his evidence was terrible.
My application was not nonsensical, number one.
Just one moment.
Number
just,
two.
Just one moment. And that was after I admitted the statement in which he acknowledged his participation in the commission of the crime. But you apply for a discharge on section 174. A court admits a statement that amounts to a confession, albeit on a different factual matrix, and counsel gets up and applies for a discharge, because the test for a discharge is there is no evidence upon which a reasonable court can convict. Then such application must be nonsensical.
What happened to the principle of adversarial,
So what?
the principle of odi altem,
So what?
and the principle of a fair trial?
Ms. Nkabai, are you serious?
I'm very serious.
Right, I hear you. Carry on.
The court had, before I even start my arguments in section 174, the court remarked, I didn't expect accused number 2 to move an application for discharge.
Yes, I did say that because I didn't expect it.
Was not pre-judgmental?
No.
Was that not a pre-disposition?
No, Ms. Nkabai. You see, let me explain something else. I don't know where this new thing comes in. That almost in every criminal case, you can see there's an application for a discharge. Even in cases where there's a confession. Because it seems to me it's used for other purposes. The same with drafting heads of argument sometimes. But courts can't just sit back and just allow things to happen. I didn't stop you in bringing your application. I said I was surprised. And if there was anybody ever on the bench that is not surprised under those circumstances, that counsel will have the audacity to stand up and bring an application in terms of 174, then I don't know.
Hence, my lord, the defense is bringing this application for leave to appeal, because another court will decide that point
Yeah,
differently.
Of course, the
Especially-
test is a reasonable court, applying their mind.
Especially, my lord, when you take into account how this confession was taken, and when taking into account the background of the confession, I strongly submit that we have prospects of success in appeal, and this ground, those remarks by the court, are compelling grounds.
Yeah. Anything else?
Yes, my lord. I want to deal with all the remarks. Still, when my client was, no, not when he was testifying, when Ms. Sonnepoel was cross-examining him, the court had this slogan: open quote, it is what it is, Ms. Swanepoel.
Yes. It is what it is, and so what?
My submission is that that remark or that slogan was excluding or excluded or had a perception of excluding other people. I'll speak about me. Because
I was excluding you.
Because I didn't know what is.
Ms. Nkabai, if a court engages a witness, whether that witness is an accused or not, I would be surprised if you have to defer to counsel first whether you can ask this question or make this comment. But you felt excluded. I'm sorry that that I excluded you and that I offended you in that way. What's in the submission?
In the submission, my lord, the perception that one can draw from that slogan is that the court was aligned with the state. That is my argument.
Okay. Yes. You can move on to another point. Something with substance.
This is with substance, my lord. And when the court is aligning with the state, that is very, very, very irregular. It is having substance.
And again, there was no entry made. Because then you failed your client. Then you didn't do your job. If this is what you argue. Then you must self-report to the LPC for failing to do your job. If these are the grounds that you now raise that was not raised before, then please self-report if you're serious about it.
I'm very serious, my lord.
Okay.
I'll go now to when Ms. Swanepoel was addressing the court in judgment.
Mm-hmm. In argument?
Yes.
On the merits?
On the merits, yes, my lord. Still alignment. When the court aligns with the state. When she was busy addressing the court in judgment, the court erred. And this is a compelling ground. Prospect of success.
Okay, let me take me to your notice to that ground, because I saw that mentioned somewhere. I saw it somewhere that yeah, no, it's not that one. By agreeing with Ms. Swanepoel on certain things when she argued the case.
Now, I'll be specific, my lord.
Now I'm looking for the point. In your
56. My lord, it might be paragraph 56.
yeah. Yeah. So 36 in the notice. All right. So so what do you say I did wrong there?
The court erred, I submit, and this is a compelling ground
No, but it
Or
wouldn't,
prospect of
it
success.
wouldn't be erring. I would have done it deliberately.
Ms. Swanepoel, what do you think I must do with the piece of evidence where Section 204 states that she took Joshlin to the car? Right in the middle of Ms. Swanepoel's address in judgment,
Yes?
Ms. Swanepoel kept quiet,
And then?
and then the court continued.
And I continued, yeah?
Mhm.
And then?
I thought you were going to address me on that.
Why? Did you feel excluded? Because I didn't ask you the same questions.
The dialogue continued.
Are you serious, Mr.
I'm
Kabai?
very serious. This is what the court
I'm
wants.
asking you now, seriously. Are you serious in making these submissions in this application for leave to appeal? Or are you playing for the gallery or trying to make up time?
My lord,
Now you're going to blame me again for that comment.
my lord, partiality of the bench
In argument?
in argument before even the defense argue those points. In a case where the same 204 told the court that Joshlin was taken to the polo. Now the court is telling us, I'm going to exclude that piece of evidence. How can that not be important?
Ms. Nkabai, carry on. How long are you still going to be?
I'm still going to be long.
No. You're going to go to each of your points that you've raised in your notice, the ones that we haven't covered, and you're going to address me on that. We can start with this notice because you are now just batting here as in a 5-day cricket match, and you're not scoring any points.
Let's hear the other
Wait,
court if you should say the same thing.
let's go to point number 1 on page 2 of your notice. You've dealt with that. Point number 2, we've dealt with it. Point number 3, we've dealt with it. Point number 4, we've dealt with it. Point number 5, we've dealt with it. Point number 6, we've dealt with it. Point number 7, we've dealt with. Point number 8, we've dealt with. Point number 9 is all part of that confession issue. We've dealt with that. Point number 10, we've dealt with. Point number 11, we've dealt with. Now, point number 12, you haven't dealt with yet. So that's the evidence of Mr. Chosa. I see it's spelled Tsota in your notice. So let's deal with point number 12 on your notice to appeal.
With due respect, my lord, can I first close the point
No.
I was doing?
No, because we're going to get there. Because you're wasting time, you're going in circles, and we're not making any progress. You filed a notice, and remember you had your notice ready on the day that I gave sentence. You had it ready. Because in the morning, before we went into court, I called counsel to what was my temporary chambers. And I said to the parties, I am not going to deal with the leave to appeal today. You had the document in your hand. That's when you said, when you made the remark, you wanted to, you didn't use the word embarrass, but that's what you said in the presence of all your colleagues in that office. That is why I told you yesterday, here's your platform now. Because you said, that's all the media here. Now here's your platform. Now let's go there and that's why I asked you earlier whether you're playing for the gallery.
My lord?
Because some of these submissions you're making is so far-fetched. It's not factually correct. But I'm going to take you through your notice and we're going to deal with each and every paragraph of the notice that you gave, the ones that we haven't dealt with. And that will be the end of the discussion. Once we've exhausted your notice, because I've given you enough latitude, much more than what any of the other parties at trial was given. And in this application, we have now going around in circles. You filed a notice. You had ample time to consider the notice, ample time to add to it. So I'm going to deal with it as it is before me and keep the parties to the four corners of the documentation. So in paragraph 12 you say, I urge in fact and in law, by accepting the testimony of Ms. Sosa, despite the fact that the witness filed 2 affidavits containing material contradictions on the key aspect of time. What do you want to say about that ground?
My lord? Exactly what I said.
As they, you want to add anything to it?
I'm not developing that.
Good. The next one, of course, we dealt with Captain Sekwe, where we dealt with when he had the interview with your client. 14 we've dealt with yesterday. 15 we've dealt with, that's Ms. Mart's allegation that it was hearsay. And then, just see, is Mr. Kutsia in that same, no, Mr. Kutsia is not in that paragraph. Untested hearsay evidence, what untested hearsay evidence was that? Is that referred to Ms. Mart and Mr. Kutsia that you dealt with yesterday? Now we haven't discussed the Kutsia hearsay evidence. What evidence of Mr. Kutsia was hearsay that was admitted?
Mr. Kutsia, my lord. Told this court in his testimony that somebody else told him that the following year this is what is going to happen. I don't want to go to the merits of
No, but it was Ms. Smith that told him that.
It was who, my lord?
Ms. Smith. He said Ms. Smith told him. Kelly, accused number 3, told him that. On that cold morning in August of 2023. There opposite the open field where we parked our cars when we went on the inspection. That was his evidence.
It is in the
So
same
how does that qualify as hearsay evidence?
It is in the same breath as Mrs. Mark's evidence. I'm not going to develop.
How can that ever be hearsay evidence?
My lord, I'm not developing.
He says the accused told me. Me. Okay, there's a new category of hearsay evidence, it seems. If you have authority that I urge to admit it, please give it to me. Because I've never heard
I've just said now, my lord,
Yeah.
that that
Are
ground,
you abandoning that ground?
ground will be treated as same as the ground
No, no.
referring to the evidence of Ms. Swart.
Are you still persisting with that ground? Talking about Mr. Kutsia now. Are you still persisting with it?
I'll leave it as is,
No.
my lord.
No, no, no. Are you persisting with it? Or are you abandoning the ground? Because if you persist with it, I want authority for the proposition.
I will leave it as is
No.
on my ground.
I'm asking you, are you persisting with it? Because if you're leaving it as is, I want authority for that proposition. That evidence of Mr. Kutsia that he gave was hearsay evidence.
My lord, I've already answered.
No, you haven't. I've asked you a direct question. Are you persisting with that ground? Yes or no? I'm waiting for an answer, Mr. Kabay.
As the ground in Xhosa, my lord, I will leave that one as is.
I am asking you about that, yes, sir. Yes or no?
I don't have the other answer, my lord.
Okay. Let's go to the next one. That one we've dealt with, 17. 18 we've dealt with. 19 we've dealt with. 20 was the one of the dialogue with the state. Right? It finds its way later again, but what is this in 21? That I erred in law and in fact by allowing or failing to address the prosecutor's conduct in editing and or amending the section 204 confession during court proceedings.
Thank you, my lord. I will take the court back to the evidence of 204. The prosecutor, Ms. Fanepo, amended the confession of Ms. Lombard.
The confession, that was the one that was given to Captain Sillier.
No, not that one. The one of Lorenz Lombard, Laurentia Lombard.
That's right. The woman with the grey hair.
I objected to that.
No, I'm just trying to figure out which document we're talking about.
We're talking about the confession.
Yeah. So that was that statement.
Lombard, my lord, has...
I think it was the 13th of March, if I remember correctly, that that statement was taken.
I do that. I objected to that.
Uh-huh.
Asking whether the court is going to allow the state to edit or amend
Yes,
the confession.
yes.
I didn't get any response from the court.
It was allowed, of course. So what? Because it didn't deal with the substance of the matter. Graad 5, grade 5, standard 5. It had nothing to do with the merits of the case.
But still,
But I take your point that you raise it. Can you, do you want to develop it further?
I will leave it as is, my
Good.
lord. I think it is clear on the grounds.
All right, so now you dealt with the International Legal Authority yesterday. Did you find the citation for that?
Yes,
Rex
I did.
versus Collins?
I did, my lord.
So what's the citation?
And where I've mentioned it in my head with
Yeah.
the leave of the court.
So no,
Can assist
I
me.
just want to see whether it's the same case that I've opened. Which one is that? If it's Rex versus Collins from the...
Paragraph 3, that's where I've made mentioned. I mentioned...
No, I'm talking about define the case. Did you find the case?
Yes. I think I did for the court.
This is the same case. This is the same case that I have. Here, the name is just Ruby Collins. But this case is just... it's just cited differently. It's the same case that I have, that I found afterwards. And it was not from Scotland. It was in fact the one from... I've read the case, so you can have the document back. I've got it open in front of me. So that's the one where I said to you, you must quote closer to home.
That's correct, my lord.
So that's the what was the point you wanted to make with that case?
Exclusion of evidence obtained unconstitutional.
So there are many authorities in our law, both in the SCA and in the Constitutional Court. But in any event, when you quoted that case, have you read the case before you quoted?
Yes, I did, my lord.
And what was the point in that case that you wanted to bring to my attention?
I wanted to bring before the court's attention that the issue of unconstitutional obtained evidence, it's a constitutional issue. It is not only discussed locally, even internationally.
It's
Constitutional rights are
it's a principle that's tried. But in any event, the Ruby Collins case can be distinguished on the facts from what we were dealing with. Ruby Collins did not deal with extracurrial statements. That had nothing to do with it. In any event. Remember at the time when you raised it at the 174 and at the admission of
trial within a trial.
At the trial within a trial, you didn't give me the case. In fact, the reference in your heads was different. I went to search during the course of last week for any case that I could find that has the citation R versus Collins.
With due respect.
Just one moment.
Okay.
But in any event, at the trial within a trial stage, this would have been irrelevant because it had no bearing on the facts. This one dealt with a search. The Ruby Collins case. This is the person that was suspected of heroin dealing. And she was searched in an unconstitutional way. I'm not going to describe all the facts. And it was on that basis that the majority found that evidence must be excluded as to what was found.
With due respect.
So on the basis that if the evidence that the heroin was found in a body is excluded, out goes the conviction. It had nothing to do with an extracurrial statement.
With due respect, my lord, I beg to differ with court.
Okay.
It had everything to do with the principle excluding evidence obtained unconstitutionally. It has everything to do.
Okay. You say that.
with the constitutional rights.
You say that, and I've learned now the last 2 days, if I didn't learn during the trial, doesn't help to argue with you.
My heads of argument on the last
Right. So
query by the court, my citation of this case when I was addressing the court was full. It is full on my
Ms. Nkabai, we've now dealt with 22. We're going to go to 23. Right. You say I committed a gross irregularity by storming out of court in anger during lawfully defense submission, returning in a hostile and emotional state, and arbitrary ordering the defense to conclude all the factual arguments within 10 minutes, regardless of the complexity and seriousness of the nature.
With due respect, my lord, prospects of success in appeal,
So,
hostility, anger.
so what's the test on? You remember, you're applying for leave to appeal.
Yes, my lord, I'm applying for
What
leave.
you're alleging here is an irregularity in the proceedings. Not that I'm going to defend myself, because there's no substance in what you're saying. The record will reflect. I recall that afternoon very well, Ms. Nkabai. You did no different to what you're doing here in the last 2 days. All over the show, quoting cases left, right and center that had no bearing, and cases that you clearly did not read, despite my warnings before that. Then when I asked you about the case, there was an impasse, and then I said, good, before you proceed with this case, I'm going to fetch my laptop and I'm going to set it up similarly to as it's set up here now, and then as you are addressing me, I will go through the case. Of course, after the staff had put up everything, I came in and I said, okay, let's go to that case. I have it open now. Let's discuss it. Because I knew you were barking up the wrong tree. Then you back down. But the record is what it is. And you say, I like those words. So if you want to take the point wherever, feel free to do so. It's not a ground of appeal, but in any event, in the event that I should grant leave, the parties will have an opportunity to file a proper notice of appeal to the court, to which leave is granted. Then you can include whatever grounds you wish. But I cannot debate that with you. I would urge you, Ms. Nkabai, if I acted in any way inappropriately as a judicial officer, please feel free to report me to the Judicial Service Commission. I'll be more than happy to defend myself. But it's reckless of practitioners to just throw out things, and especially if it is without substance. But you have, I take it you have the details of the JSC. Please feel free to report me. And if any member of the JSC see this in proceedings, they can initiate proceedings mero motu.
With due respect, my lord,
Good.
that is my ground for leave to appeal. That is
Yes, it's noted.
That
It's
is
noted.
what exactly happened on that day.
Now 24 we've dealt with. 26 we've dealt with. 27 25 and 26 we've dealt with. 27 we've dealt with this morning. 28 we've dealt with. All right, so now we get to 29. The shopping thing. You want to say anything further on that ground?
No, my lord.
Okay. Paragraph 30 of the notice.
I think I've dealt with
That, no, that you've dealt with. I'm
in my
taking
174.
them
Shopping.
one by one now. Right. So that
Thank you, my lord.
if you go to another court and say that I didn't give you an opportunity, at least there will be this record, as there's a record of all the other allegations you make. 31 we've dealt with. 32 we've dealt with. 33, do you want to add anything that I created a hostile environment
Yes, my lord.
and denied your client the right to be heard?
Yes, my lord.
Uh-huh.
I'm sorry. I have to develop this one. It affected me.
Yes.
The persistent hostility and aggressive tone adopted by the trial court during trial within a trial proceedings severely impaired.
All right, so give me examples.
The court on that day, I was arguing a crucial application. Admission of a confession that was taken in that manner.
And you relied on cases that you haven't read.
How does the court repeatedly making this assumption that I'm coming to court and making references to the cases that I didn't
Because I asked
read?
you what the facts were and you couldn't tell me.
In-
Similarly, as you've thrown out names here in this application, and you mention in your note the shopping case, and by the way, it's spelled wrong, and the reference is incomplete.
In my heads of arguments, my lord, I was reading them.
No,
And
you
head-
had head notes, but you're saying I created a hostile environment,
Yes, my lord.
right?
Yes.
By not allowing you to fully ventilate and present your submissions.
Exactly, my
You
lord.
want to add anything to it? You want to add anything to it? You've now given me the example of where you wanted to argue the law.
My lord, the day of the trial within the trial was not the first day. I remember the other day, without going to the merits of the case, I remember the day when my client couldn't make it in court. The manner in which the court addressed me,
When
very
your
hostile
client,
indeed.
when your client couldn't make it to
The
court.
witness who were calling a witness in our trial within a trial.
Uh-huh.
That witness, the previous day attended court. On the second day, he couldn't attend court because his tooth was being extracted.
Now, how can that be a ground of appeal?
It can be.
I invited you at that occasion to make a special entry if you so wish.
It will be a ground of appeal based.
So then also you failed in your professional duty towards your client if you didn't do that.
To do what? I didn't hear
If
the
you
last
say
part.
that I committed that gross irregularity in the case, and I invite you to make a special entry, and you decide not to do it, then you're not acting in the interest of your client.
That was not the only relief to make an entry. That was not the only relief.
Yeah.
My lord,
Yes.
I'm using this platform now.
Yeah, no, you were looking forward to using the platform because you said you want to show me up. So, continue.
The last ground was hostility. When I was reading it, then the court stopped me. I don't know whether I must proceed.
No. I hear what you say. You said, I denied your right to be heard on the submissions. Now we've dealt with that one because now you're turning to a witness. There's a difference between allowing or disallowing you to be heard and the hostility. I thought we passed that.
My lord, I was combining two incidents
Yeah?
of a clear aggressiveness of the court
Yes.
towards me. That's why I mentioned the day when our witness couldn't make it in court.
Yes?
A clear record, my lord.
The record will speak for itself. That if you get leave, you can add that and argue it before the court. I'm not going to defend myself on that.
Can I
And if you don't get leave, you can raise it on petition to SCA and Constitutional Court and so on. And I already invited you to lay a complaint against me.
Can I finish the
Don't have
sentence?
time to answer to it, but
Can I finish the sentence I was reading, my lord?
yeah.
A clear record of judicial aggression
Are you reading from some other document?
from my notes.
From your notes?
Yes.
Okay.
Undermines impartiality. And that's a compelling ground for you to appeal.
Okay. I note that. Right. So number 34 we've dealt with. There are two 34s, right? So the first one is about wiping the floor. That you say happened, when it happened. The record will also speak for itself on that. The second 34, you say that I remarked that the applicant chose to remain silent because he wants to take his chances on appeal. So when did that happen?
It happened immediately when we advised the court that we're not calling our clients to the stand.
Before judgment?
I can't remember clearly.
No. You say I did it. So when did I say that?
When you say when the court asks when, before judgment or after judgment?
When was that said?
My lord,
You're making the allegation.
Yes.
So when was it said?
It was said after I told the court that we'll be exercising our right to remain silent.
Yeah. On that day.
Even if it was not that day.
No, I'm asking you.
No.
Because you're making the allegation. So when did it happen? Because context is everything.
The record, my lord.
This
tell
was in
us-
an engagement during argument, either on sentence or on the merits. But I'm asking you, you make the allegation. When did it happen?
I make the allegation, my lord, because I know it happened.
No, but
As
when?
to when, I don't
When
know.
and in what context?
It
was
was
it said?
after. It was after. We've chosen, my client chose the right to remain silent.
You see, I cannot remember when, but there was a debate about whether lack of remorse is a factor at sentence. And I confronted the prosecutor to say, but you can't just say that because he's not coming clean, that it doesn't show remorse. You can't, it's not limited to that. Because he might want to take his chances on appeal and not admit now. That instance I can recall. I might have mentioned it at another stage as well. So I'll note it there, not that that would be a ground of appeal, but I noted it. All right? 35, where you say that I made disparaging remarks towards the defense, including the accusations that they were fishing, buying time, and wasting the court's time during cross-examination and legal arguments. I admit that I did that. Whether it was disparaging is not the case, but I did raise points like that, because those were my observations as they are here today. Similar, and I make no apologies for it, because courts shouldn't just sit back and allow counsel to take out all sorts of sideshows. And yes, it's happening again. So I'll note it, that you can argue it before another court if you so wish. 36 we've dealt with earlier on. You say that I overruled and restricted the defense rights to cross-examine state witnesses.
Yes, my lord. Thank you. 204. In her evidence, she never mentioned that there was a meeting.
No. The point here is that you say that I committed a material irregularity. Again, we're going onto a different field than an appeal. By unnecessarily overruling and restricting the defense rights to cross-examine the state witnesses, plural, including a Section 204 witness on crucial discrepancies and material contradictions in their evidence.
Yes, my lord. When I was cross-examining 204 regarding the issue of meeting, the court overruled me and said that was out of context.
I overruled you many times. I also prevented you from continuing asking the same question over and over. But despite that, it happened continuously. No problem with that. You can argue whether my interventions during cross-examination was justified in the event that you go on appeal. Well, what does that make a difference at this stage? But I can note it, that it's in your notice.
My lord, I will submit. It will make a difference, especially that I was overruled to cross-examine on a critical issue, a meeting that was not there, a meeting that was going to, at a later stage, be referred to as common peoples.
Okay. Anything else on that point? So let's then go to 38. So what is the point you want to make here about the body language of the prosecutor?
sign language. When Ms. Swanepoel was leading evidence of 204, I objected this. He put a question to her. She couldn't answer. She looked at Ms. Swanepoel. I was observing them. Ms. Swanepoel made this sign. Immediately.
She shook her head from
yes,
left to right.
Immediately, 204 answered, no. I stood up. I objected to that.
And?
Ms. Swanepoel didn't oppose to my objection.
And?
There was no ruling from the court.
So what? So what?
It is a ground.
What must the court do? And I can't recall it, right? Because if it was brought to my attention, I would most probably say, Ms. Swanepoel, just don't shake your head like that, or don't frown like that, or something to that vein. But so what?
This is
Do
the
you
answer.
strike that answer from the record?
My lord?
Or because it's been given? It's out there. It's on the record. So where's the irregularity?
There is the irregularity.
Okay.
What kind of witness we're talking of?
I hear a lot of new things.
What kind
I'm
of-
learning. I think we must take a few more days.
What kind
So
of
I'm learning a lot of new things.
What kind of witness we're talking about here? It's a 204 witness. If now 204 is being posted, is that not going to affect the inquiry whether she answered her questions?
Ms.
Frankly-
Nkabai, is this not one of the issues that you will throw into the mix in the event that you go on appeal as to the acceptance and reliability of the 204 witness, with all the other issues that you've raised? So it can go on the same pot as the attack on the credibility of the 204 witness. To say that I shouldn't have relied on anything that she said because of A, B, C, D, E, and that the prosecutor suggested an answer to it.
My lord, we note that ground
Yeah.
as a compelling ground.
Yeah. So that's a compelling ground to grant leave to appeal. Okay, I'm noting it. Yeah, 39, you say I committed a procedural irregularity where I ordered the defense not to read the contents of legal authorities during its submissions on judgment, but instead only provide paragraphs for me to consider later.
That's so, my lord.
Yes? So what's wrong with that?
And the court erred on that.
What's wrong with that? To say, don't read the whole thing to me. I'm in any event going to read it. Just give me the paragraph numbers that you're referring to.
Before we go there, my lord, when I stood up to address the court in
Yeah.
judgment, before I even addressed the court remarked, Ms. Nkabai, I have read your heads of argument.
Yes?
It will be not necessary for you to address me on the honors by the state, to address me on the credibility, on the will of the witnesses. That was very important. It was not only for the court to read. It was for me representing my client.
Ms. Nkabai?
Yes, my lord.
I note that ground that you can argue if you get leave. Let's go to 40. So I committed procedural irregularity and the denial of the right to be heard, where I interrupted and prevented the defense from fully citing and relying on the inquiry of the late Abdullah Musa on the basis that it was well known. In fact, it was not the inquiry of the late Abdullah Musa.
It was the reopening of the inquest.
No, but that was not his name. This is not correct.
It's Imam.
This is not correct. This note that you're saying that I said it's well known. It's not that inquest. Though the name that's here. It's Imam Harun.
It's Harun. Harun, not Marun. Harun.
Harun. Imam Harun.
Imam Abdullah Harun.
Yeah, no.
Even
But
if my
yeah, it says the late Abdullah Musa
he was
on
known
this
as,
document that you filed with me,
at
the one
times-
that you wanted to give to the press on the day of sentence.
At times, my lord,
This is wrong.
he was referred to.
This is wrong. You never attempted to discuss that, any estate like that. The one that you wanted to refer to was the inquest that was held recently, in the recent years, where my brother Tulare presided. And it is a fact that it was well known. And there was no need to look at the inquest judgment because I read it beforehand. But I don't need to defend myself against these allegations that you make, Mr. Nkabai. I will note it, but whether it's there, somebody else can decide. I'm not gonna entertain further argument on that. You've made your point, and we've now corrected the error in your notice. Unless, of course, there was another estate late that I was unaware of, but the one that I saw was Imam Harun. I'm moving on. Let's move to 41. You say, I misdirected myself by finding the state had successfully proved its case beyond a reasonable doubt, despite the fact that the state failed dismally to discharge the onus of proof on key aspects. The state did not need evidence to establish exploitation or slavery. Despite that failure, was convicted. Now we're dealing with the merits. So let's have some sensible argument for the change.
Would you respect my lord?
Yeah.
That is a compelling ground for
So which of the elements of the offence was not proven by the state that you say they were key aspects of the case? Which of the elements of the offence?
all of them, my lord.
Of both of them? All of them?
All of them.
All right.
We're talking about savior. That the victim was sold.
No. So what are the elements of the main charge that they were convicted of? What? Did the state have to prove beyond a reasonable doubt? Because I'm reading in here there are key aspects. So let's take them one by one. What are the elements? The elements of the offense.
Exploitation.
So we're looking at the act, causation, unlawfulness, intention, all those elements, and then we can distill them. You want to go to the... Fortunately, I've got my court file back on the bench. I went on a walkabout yesterday. So let's go there. So we're going to look at the elements of the offense. Remember, you make this allegation, so...
Yes, I did, my lord.
So, okay, So let's deal with it. Yep, I'm ready. Let's
Yes, my lord.
distill it,
Yes.
right?
We're talking about-
Let's break the silence.
The allegation by the state.
No?
is
What are
that
the elements of count 1 upon which your client was convicted?
intention? My client never intended to commit any offense.
Did the state present any evidence, admissible evidence, because we're starting from the back now, that he performed an act? And when I say performed the act, you can participate, be an accomplice, da, 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 right? So let's start with the act, because if we don't have an act, doesn't get to the intention. An act.
My client didn't act, my lord.
Did the state present evidence of an act?
It's only 204 who testified.
And what about your client's own statement that was admitted?
My client never testified to the intention
No.
of selling.
No, I'm dealing with the act now, right? I'm dealing with the act first.
My client acted in selling the microwave on that day.
No,
Never-
on the evidence that was admitted, Ms. Nkabane. You're saying that I misdirected myself by convicting, and I'm putting the paragraph into context. The applicant, your client, where the state failed to discharge the onus of proving key aspects of the case. Those are the words used.
Yes.
So the key aspects of the case that they need to prove are the elements of the offense. That an unlawful act was performed with the necessary intention and in certain instances with a potential result, where you have a causative issue. So all I'm asking you is evidence that the state presented on the elements.
My lord,
Now, let's cut a long story short, because I don't want to confuse you unnecessarily. Forget about the other evidence. Right? Your client says, I went with. Joshlin was sold. I went back for my cut the next day with the 5,000 rand. So, clearly, just on a simple reading of that, the selling of a child is unlawful. And you don't do that negligently if you participate. You do it intentionally. That also covers the elements for the kidnapping charge. And we can go on and on and on, and we can make vague allegations in applications. It's all about what the evidence was. That's what I'm saying. If normally one would just phrase this to say the court erred and misdirected itself in finding that the state had proved its case beyond a reasonable doubt, not satisfying all the elements of the offence. And say it's arguable on the facts that even though it was only the state's evidence, because there was nothing to gainsay it, that properly considered the state failed in this or the other following respect. But it's styled in the way that It's more an attack on the court than what it is on the facts. But that's fine. I take it.
My Lord, do I have to respond?
If you want to.
The evidence of my client.
There was no evidence from your client, Mr. Kabai.
During trial, within a trial.
That evidence was in the trial, within a trial. We've dealt with that yesterday, and I thought we've exhausted that argument.
The issue of him going to Makalima, getting 5,000, is coming from the evidence from the trial in the trial.
Ms. Kabai, let us not misunderstand each other. You and I know, or at least we're supposed to know, that when I refer to the trial within a trial, it's the outcome of that that gets into the main trial. The statement that was admitted and the contents thereof. Whatever evidence was led in order to come to that conclusion, we dealt with this yesterday, is of no moment, because it's insulated from the main trial.
My Lord?
So all I'm interested in is the contents of the statements that were admitted. End of the story. Don't?
If the court can remember
Yeah.
how that statement came about, how that confession.
We way past that, Mr. Kabai. We've dealt extensively with that yesterday. We've revisited so many times. We've already ticked off those paragraphs that will go, that you say, those are the grounds, all the confession grounds. That's fine, we passed that. I'm talking about this here at 41, about whether the state, what evidence the state had. So the evidence the state had with the contents of those statements, plus circumstantial evidence, and lots of it. Some through conduct and inferences to be drawn. And I think we had 43 witnesses in total. And all those exhibits that we've dealt with. So don't tell me about evidence, because there was none on the merits. Nothing.
My Lord?
The plea means nothing. It's got no evidentiary value. Didn't testify, didn't call any witnesses on the merits. Finish and close.
My Lord, the ground I've laid has no mention of my client.
No, you
Has
don't.
the mention of the state.
You interpret now. That's where you got to this point about your client's evidence.
I was making a follow-up because it has made mention of this 5,000. I still maintain that the state has failed. These the charges that my client was convicted.
Yeah. So can we move on to the next one?
Yes, okay.
Okay, the next one is a general that's to say that it must be granted to ensure justice is done. It's just a general proposition. In 43 now, we're now dealing with sentence. So unlike Mr. Harms's client, your client also want to appeal the sentence. You allege there was a procedural irregularity with the victim impact report. So what was that?
My lord, the victim impact expert was appointed by Ms. Swanepoel.
Yeah?
It came evident.
No, but
During-
I think you're talking about the expert witness. The victim impact was done locally, sitting back there, compiled everything. We're talking about the expert, so I'll accept that. So you say it's because Ms. Swanepoel appointed her, but the state called her. The state called him. So,
Not that only. It was evident during his evidence that they've been knowing each other for a
So
long
what?
time. So what? Thank you, my lord. Now, the issue of independency, the issue of neutrality.
yeah, but you've canvassed that with him in cross-examination. If a party calls an expert, one would expect that party to consult with that expert before calling the expert. And you would most probably call somebody as an expert in a particular case. You as a practitioner had worked with that expert in the same field. Because you will know his or her expertise, and you will know. So what's wrong with that?
I'm sorry.
How could that ever be a procedural irregularity?
It didn't end there, my lord. I asked him, when you were compiling your report, did you use our heads of arguments? He said no. He used heads of arguments from the station. So the report was one-sided.
No, I know that. Miss Mkabai. But those are issues that affect the weight a court should attach to the opinion of an expert. If things like that, if it's one-sided and so forth. It's not a procedural irregularity. You raise it as a procedural irregularity that you want leave on appeal to, I take it, the Supreme Court of Appeal.
My lord, that is our ground
Okay,
for you to argue,
all right.
with due respect.
So that also covers 44 then, because that speaks to the neutrality. Then we go to 45. You say that I erred in my hostility by curtailing and overruling your cross-examination of the expert witness.
That was indeed my lord.
Yeah?
When I was asking the expert witness factors that were relevant into our case,
Mm-hmm.
the court cut me.
So?
It goes.
Yes,
it goes
I did stop you at some stages because you were asking irrelevant questions
with
and
due,
going in circles.
with due respect, my lord. Asking an expert factors relevant to the matter that he is called to give testimony in can never be relevant.
Okay.
This is my submission.
Okay. So 46 and 47 must be read together. Because the
Yes, my lord.
complaint here is that the court appointed the probation officer. And the suggestion is made
Yes, my lord.
that there was collusion between the court and the probation officer, between myself and the probation officer. Because the language used in the probation officer's report, this document says, was traceable to me. So the allegation is made that I colluded with the probation officer in producing that report. Now we know all this, although this document, I don't know whether all of this was there on the morning when I sentenced.
Common cause of worship.
Because this was drafted before I even sentenced. But I don't know where this comes from. And I'm not going to defend myself. But maybe you can tell me,
Yes, my lord.
when did I collude and where did I collude and behind which tree I sat with a probation officer to tell him what to come and tell me on sentence.
Okay.
This is how preposterous it sounds.
If the court can remember, when the probation officer was giving evidence, there was a remark from the court.
What was the remark?
That the report was comprehensive.
Yes?
That in 20 years the court hasn't seen a comprehensive report.
I
like
don't
that.
think I said 20 years. I might have said many more than 20. Because I've been on this bench for many, many years. I started here in 1999. Although I was only permanently appointed, more than 25 years ago. And I've been around. I'm not going to mention the years just now, it becomes a TikTok meme.
That comment.
But I did make the comment that I have not seen such a comprehensive report.
And that comment.
And because of that, I colluded.
I'm still
Yeah.
explaining the basis of that ground, my lord. That comment was made directly.
I hope you want to repeat this outside of the courtroom as well.
What is it that I have to repeat?
All these allegations you're making against me,
They are for the
being
court.
corrupt and because that's what you say.
They are for the court, my lord. Not
No,
for
no, no. I hope you're willing to repeat it outside of the four walls of this courtroom. You're now doing it on national television. I am quite happy to face it. But what you're saying is I colluded, and the first reason is because I made this comment about the report was comprehensive. And what's the other reason?
the other reason why the probation officer was busy giving evidence. You interjected.
I interjected while he was giving evidence. Okay?
Saying, you remember when I called you, I asked you to prepare the reports.
That I called him.
It's on the record.
That
my lord.
I called him. I have not met Mr. Peterson until I saw him in that court on that day. The requests for the reports were made at my request, but through the office of the registrar. The communications were from my registrar when the pressure was put on to try and complete the reports. I was not even aware about the existence of Mr. Peterson before that day when he testified. You will recall, Ms. Nkabai, that the gentleman was sitting in court. I didn't know he was the probation officer, because we were still busy with something else. And I admonished him for coming late. I didn't know the person that came into the courtroom was the probation officer. So on what basis? Maybe you should put the facts now on record so that the public can know why you're saying that I colluded with the probation officer in compiling a report. Put it on record.
Well, on record.
I'm inviting you now because you wanted this opportunity. You said you wanted the opportunity to deal with me in the public. Do it now. Place it on record, the facts why you're saying that there was this collusion. Place the facts on record.
With due respect,
You don't have to disclose your sources. Just place the facts on record.
with due respect, my lord, this is a court process.
Absolutely.
I'm handling an application for leave to appeal.
Do you have instructions from your client to make these allegations?
And
Or are they coming from yourself?
my grounds for appeal, they are coming directly from the record, from what took place
So-
during the trial.
So this comes from the record, the collusion.
I was there, my lord.
You were there, you saw the
Yes.
collusion.
I was there, my lord. I was explaining before this court.
Yes?
The court made a dialogue with the probation officer saying, do you remember when I called you and asked you to prepare the reports? Reports, they normally take so much, but you have prepared these reports within this period. Thank you very much. That is on the record.
So, and it was, whatever was said to the probation officer that you're referring to were things I said in open court.
Number 3, my lord.
No, I'm asking you, is it limited to inferences you draw because said in open court?
My lord, I am making a reference.
I am asking you, Ms. Nkabai, and hopefully for the last time, you are referring only to things I said in open court? Or are you referring to my conduct outside of the courtroom as well?
I don't know your conduct outside court, my lord. I know you in court. I know you in this case.
No, don't think I've met you before either. But I'm still talking about this probation officers. The inferences you draw of the collusion between me and him is limited to what happened in court.
Yes, my lord. Number 3, the probation officer in his report used the word commodified. Commodified.
Common? You use which words? I can't hear. Please, can you just, that keyboard, sorry, I don't want to interrupt you, but I can't hear Ms. Nkabai because the keyboard's a bit loud. Uses which words, Ms. Nkabai?
He used a word that was used by the court. Then when I asked him, but where did you get this word? The court answered and said, it was from my previous utterances in court. If the court can remember that.
I can't.
It is the court.
I can't even know which word you're talking about. But if you make the allegation, tell me what the word is.
Commodified.
Commodified.
Yes.
So, you see, remember the reports were asked after the judgment. That word was in the judgment where I said the accused person commodified Joshlin. So because he used that word in the report as well, I colluded with him. That's what you're saying.
Including the above.
No, including the above.
Yes.
I hear you. Okay, is there anything else why you're saying that
Yes, my
I
lord.
was in this corrupt and collusive relationship with the probation officer?
When I was
Just so
addressing,
that it's on record.
when I was addressing the court, my lord, I mentioned that the court called the probation officer.
I instructed for the probation officer's reports to be compiled. And I've disclosed on record that there was going to be a delay and that I had intervened on that weekend. Didn't speak to them directly. We did it from a higher level to put pressure on the department to compile the reports. And that I disclosed on record.
Even the probation officer's report, to my surprise, when he was compiling his report, our heads of arguments were not inclusive. So his report, also my lord,
So-
was one-sided.
So let's just pause there. Let's just put the record straight. Because facts are being distorted here. I'm not interested in myself. All these things that are being said. And I will not take steps for unprofessional behavior. That's up to the bodies to do it. Whether they want to take steps against me, I'm fine. Whether they want to take steps about you, about the allegations you make, that's your business. I will not become a complainer. But at least it's on record. So the true facts are, not the distorted ones, is that the applications were prepared here in Cape Town by the registrar. When I raised it with the parties, I said the forms are already typed. And you were given an opportunity to provide further information. It's on the record. Whatever you want to provide to the probation officers. And I'm aware of when people were brought to the court for consultations, to assist with the consultation, to this building, because I authorized it. So the things that were happening in the background, also to assist the defense. And when the eventual documents went out from this court, from the registrar's office. Now you say, because you didn't do your job, that the probation officer only looked at the state's heads. Everybody had the opportunity to send in their stuff. I said it on record.
With due respect, my lord, heads of arguments were not further information. Heads of arguments were filed in court.
So what's wrong with it? What's wrong with it if you had the heads of argument?
Everything is wrong about it, my lord. The report is one-sided.
But you had the opportunity to cross-examine him, and I had the opportunity to evaluate it. If you say that I erred in evaluating his reports and made certain findings, that's fine. But why do you have to impugn, and it's actually criminal conduct, on everybody else that doesn't agree with you? Without substance. Even now, looking at what you're saying about the, because I've invited you to place on the record the allegations against me. I've invited you. I've now invited you to place it on record in relation to the probation officer. And you come short with what you're telling me. Because you had the opportunity to confront him, you did. And I evaluated the evidence. It's not about him. It's about my findings. Attack my findings.
With due respect, my lord. And again, these are
And
not...
of course, Mr. Peterson can do what he wishes with what had happened here today. I can't speak for him. But he has rights too.
I'm not bringing before this court allegations against the court. I'm bringing before this court grounds for leave to appeal.
Miss Nkabai. And I have to be careful because I still have to make a ruling in this case. But I can assure you, whatever allegations you've made, because they were allegations, I will not hold against you or your client. Because everybody that has followed this case and that has seen these proceedings, they can judge for themselves. They can judge for themselves and they can say whatever they want to say about the merit or demerit of whatever happened in this court, because it's a public court. But be careful, please. Mr. Peterson in this case is not a litigant. Not a party to this case. He was merely a witness that performed professional service, not to impugn any unnecessary and unfounded conduct on his part that will impugn his dignity. He's not here to defend himself. I can speak for myself. And I have no reservations to do that. So just be careful, let us act professionally. Because I think what is happening here is that all sorts of allegations are being thrown around. And when I ask for a factual basis, so that it can be on record, nothing is forthcoming.
My lord, in my application, I am limited to what happened in court. What I've just submitted before this court now is what happened when the probation officer was giving evidence.
Okay. Shall we move on to 48? You say I didn't want to hear anything about Machichi?
Yes,
because
my
I
lord.
said it wasn't
Yes.
going to help you?
Yes, my lord. When I was addressing the court
Yes.
in sentence.
On sentence, yes.
Yes. You stopped me.
I stopped
what
you.
my tweet is not going to help you.
I stopped
further.
you. Yes.
And with that face, my lord.
With that face, I stopped you. Because I should have stopped you here already today. But I didn't. Because once a point is made and an authority is known to the court, because Machichi, it's so well known, it's quoted every day in all sorts of courts. I know the case, so there's no reason for me that counsel address me on it. So I make no apologies for stopping. Yeah, 49. Robbie.
Come again, my lord?
No, you say that I erred in law and in fact by manifesting my hostility, by interrupting and interfering with the defense, I take it that's you, while citing Foot's comments in the case of State versus Rabi.
Yes, my lord. My lord, if you can see your face when you were addressing me.
Oh, you want to take my face on appeal?
No, 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 no.
Because, no, I'm dead serious. We're dealing here with a substance.
Yes, my
So
lord.
don't say, how is the SCA or the appeal court going to see what my facial expression was?
But I've seen your face.
So you raise this because of my facial expression?
Yes, my lord. Your facial expression, my lord. Your facial expression.
Thank you,
my lord.
Ms. Nkaba. You know, the last 2 days I've been very educational. I've learned such a lot.
From your facial expression, my lord, I could see that you are angry. People like this.
I don't think you've really seen me angry where I was really angry like this morning.
I don't want to say that because I've seen.
Not in court, when I arrived at the building.
So that face alone, my lord, will change the environment to be hostile.
I'll remember that.
It was a pain to me.
Yeah. You know, on a lighter note, so that we just break the ice. I was told that as a cross-examiner, I had all sorts of mannerisms. I think the only person that might know is Ishmael over there. And sometimes the magistrates would caution me, or the judges would caution me to say, advocate, please, that leg. And I always tried to make fun of it by giving a snide comment as to why my leg was so crooked or something like that.
I'm
throwing
sorry
the
to cut you.
spectacles. But now I've learned something else, you know, except for all of those things, I also have a face.
If, my lord, you have seen yourself,
Isn't it?
when you were leaving court on the day of R versus Collins, you took 1 second to leave the court. The way you were so fast.
I wanted to come back. That's why I left fast. Remember, it was late in the afternoon. I think it was after 4. And I wanted to come back into court as soon as possible, because you were frustrating me. And I wanted us to get done. But then you backed out of the fight. Strangely, it's not raised here as a ground of appeal. Because you dared me on legal authorities. And I took up the challenge. I brought my laptop and my screen. And I said, let's rodeo. But it didn't happen. But that's in the past. It's not a ground of appeal. But I also had an angry face then. If you give me the dates, Mr. Nkaba, maybe I can find it on the internet and I can see what my angry face looked like. Yeah. Let's get back to business. So okay, so that's the number 49 is to do with my facial expression. Number 50, again my hostility, interfering, interrupting, and overruling from re-examining your client.
Yes, my lord. Yes. When Ms. Swanepoel was cross-examining my client, she put to him long questions. At some stage, I stood up and I objected, pleading with her to make the questions short and simple. I remember one question she put to my...
No, but this has to do with re-examination.
I'm going there. That re-examination resulted from that cross-examination. I remember one question she put to my client. You were comfortable, you put your hands on the edge of the table, you pulled your arms up. I objected to that. Then the court said, Ms. Mugabai, relax. You have time on re-examination. Re-examination comes. I want to clarify this issue from my client. The court said, no, Ms. Mugabai has already answered that question. That's the point, that's the ground.
Right. I've got it here.
Still on the cross-examination of Ms. Swanepoel regarding the issue of the rod, the size of the rod where he was hanging. I wanted to clarify that. The court overruled me. No, your client has answered.
But you see, yeah, I'll note it, right? But so what?
I have a right to clarify issues that were not clear on cross-examination.
Right. I've noted that. So that brings us to the end of the grounds. Now the only issue is SCA or full court. And in full court you don't have to give me reasons. If you say it must go to the SCA,
Yes,
you must tell me why. Because that will also tie in with the other compelling reason for granting leave. The two might be tied. Under 17.
Yes, my lord. It is our humble submission that court grants our application for leave to appeal.
To which court?
Full bench, Cape Town.
Okay. So that's fine. Thank you. Anything else? I'm going to take a short adjournment now. So the only outstanding issue is the authority that you can just
Nature after.
that
Yes,
you
my
give me
lord.
afterwards. I'm going to finish this matter today. Come hell or high water. So if you have the authority, I might take a half an hour break or so before I come back, and I'll give an extempore judgment on this application as well as on the 204 application. But I'm not going to delay it further. So if you have the authority, and just send it to Mr. Bro, or I'm going to take a 15-minute or so break now. I'm trying to manage the time. So it's now 20, make it 20 to 12. If I take a half an hour now, till 12:10, and then we sit through. Everybody on board? Sinkerby? Sitting around?
Yes, sir.
Okay, Mother?
Yes.
We're going to make a plan. Between the two of you, we're going to make a plan with that. Right? So, I'm going to take a longer adjournment now, say half an hour, till 12:10. Then we're going to come back. Mr. Sivnarine will then back. State will back. I take it that won't take us longer than an hour. Then I'll take a short, I'll go back for potential replies. After that, I'll take half an hour or so break and come back and finish up. So go and get your refreshments, and now that those months refreshments, we might take a comfort break in between, but I also don't want to go into the customary lunch break of the court because it's going to be busy here today. I think it's already busy outside because it's Wednesday, so it's one of our pro bono days. So the pro bono clinic is, or our pro bono desk is running today. So there's quite a lot of movement in this passage, and once you go out the door and it's lunchtime, security won't let you in again. So let's plan it that way. 12:10. Ms. Sinkerby is not here. Does anybody know where she is?
No.
No. Okay, Mr. Sivnarine?
Thank you, madam. May I proceed, madam?
Yes. We concluded with Ms. Sinkerby except for the case. She chose, I don't know where she is. There's no communication. So we will proceed.
Thank you, my lord.
Because now we're dealing with your client's application.
That's correct. My lord, my application is with regard to conviction and sentence. My lord, dealing with the grounds of appeal, firstly, it is my submission that the court had misdirected itself in the following respects. Firstly, the court had erred in finding that the state had proved its case against the applicant beyond reasonable doubt. My lord, one of the reasons for saying so is the fact that at the end of the state's case, there was still no certainty as to what really happened with regard to Joshlin. One of the elements of the offense is that a person who either exchanges, sells, or transports another person, and in this instance, we've got two conflicting versions as to what happened on that day, as to whether it was accused number 3 herself who had taken Joshlin to a white polo, as indicated by Laurentian Lombard, or whether it was as contained in the statement of accused number 1 that he himself took her and left her at the home of Makalina. That on itself, it's not clear what happened. And at the end of the case, still, my lord, the position was still the same. There was no clarity of what really happened to Joshlin. If the state had proved its case, we would not have been sitting with two mutually destructive versions. And I submit on that ground, those are one of my submissions, that the state had failed to prove its case beyond a reasonable doubt.
And of course, the evidence contained in the statements of Mr. Pollis and Mr. Van Ryn were not admissible against her.
That is correct. Secondly, the court had erred in accepting the evidence of Laurentia Lombard, the Section 204 witness. I say so because there were numerous contradictions and inconsistencies in her testimony. It is submitted that her evidence was of a very poor quality and that it should have been rejected in its entirety. That no part of it should be used as corroboration by other evidence presented to the court.
Well, is that the test?
My Lord, the test credibility would...
Let's accept for argument's sake, right, that portions of the evidence was false. Not unreliable, but plain and out false. The fact that she would have given false evidence on one aspect, why must I reject the totality of the evidence, where we have instances where the facts are common cause and or corroborated by other evidence? Let's take a typical example.
My Lord,
She speaks of the agreement on the Sunday. It's in the judgment as well. We know of her presence on that scene because of the independent evidence of Ms. Chosa. And I know that Mr. Gabai specifically criticizes the timeline. And in Mr. Apollos' statement, that discussion is confirmed. Now, why must I then reject? And I'm just honing in on that portion of the evidence. There are many other instances. Why must I then reject that?
My Lord, as already mentioned, the evidence tendered by her was of such a poor quality. It was blatantly clear that she misled this court. She was given many opportunities to come clean, to take the court into her confidence. The court itself, on many occasions, tried to calm her down and encourage her to relax and just relay her story. The defense, included my Lord, encouraged her to take the court into her confidence. She had many opportunities to speak the truth. With reference to the agreement, the court will recall that even in her confession statement, there was no actual mention of any agreement. It was only when the 204, then we hear that there was actually a discussion and things. And my Lord, knowing that she intentionally and willingly misled and lied to this court, it's difficult to say where she was being honest and where she could have been mistaken. And it happened on many occasions that when certain questions were put to her where she knew she was going to be in hot water, she just simply refused to answer. My Lord, that's not evidence of a person that you can rely on. That is why I say it should be rejected in its totality. And to add to that, my Lord, the only thing or only other piece of evidence that corroborates that is that of accused number 1. And his confession cannot be utilized against accused number 2.
No. The way the finding is structured in the evaluation of the evidence is precisely that. The contents of the statements of both Mr. Apollos and Mr. Van Ryn, that in itself wasn't used against Ms. Smith, but rather than Ms. Lombard's evidence, because it was corroborated, and that's following the precedent as to how you evaluate evidence. You don't do it piecemeal, but rather look at the evidence holistically. And also the principle, the old Latin saying about the falsum in omnibus principle, that is trite in our law, but it's also just common sense. But you can't say, I throw everything out you said, because we know, because of either undisputed evidence or corroborated by independent sources. How do you reject something that's on the face of it clearly true? And I'm not saying these specific things, but it's a matter of principle in the evaluation.
My Lord, I'm of the view that even though the court is saying that Mr. Paulus' statement was used to corroborate the evidence of Laurentia and Lombard and not used against accused number 3, I submit just by the mere fact of using to corroborate the evidence of Laurentia and Lombard to strengthen the case against number 3, it's having the same effect. Indirectly, it is still being used against her. And if one has to take that away, the evidence of, or the statement of accused number 1, we are just with only the evidence of Laurentia Lombard with regard to what really happened. And she is a single witness in that.
It's permissible to utilize a statement that's inadmissible against a co-accused to strengthen the evidence of statement.
My Lord, I would submit that no, it should not be, because that's not even evidence coming from the state itself, my Lord. That's using the co-accused to amplify the state's case. So I would say no to that.
But to make a finding of fact, if we follow the logic of saying you can't reject in totality where there are clearly truthful parts to the evidence, and the way you find that to be truthful is because it comes from the other side as well, as in this case. Is there anything wrong with that approach?
My Lord, I think it all depends on the circumstances of each case. And with regard to this case, the circumstances under which the incident occurred, the sobriety of all the parties, there were lots of factors that played a role in this, my Lord. And all of that affected the ability of the witness to even recall what really transpired. In this case, my Lord, I submit that because of all these factors, it should be rejected and it should not be corroborated by any other.
Right, so you covered that point. So that basically covers
Point number 2.
it up to point number 3.
As well, my Lord.
It covers number 3 as well.
That's correct.
Then we turn to Mr. Kutsia.
Yes, my Lord.
Okay.
My Lord, before I proceed any further, I'd just like to apply that my address during my closing arguments and reference to
Be
authorities
incorporated.
and be incorporated into this argument as well. And as mentioned previously in that argument, my Lord, there is suspicion around what Mr. Kutsia could have known or what was said to him as he had testified. My reason for saying so, my Lord, is it became clear throughout or during the trial that he had relayed this story of what he was told by accused number 3 to his employers in March 2024. Subsequently, he had made a report to a prosecutor and thereafter to the police. They interviewed him. he gave them his version of events, they released him. They did not take any further information from him, they never even record a statement. And it was the same with Tertia Kruger, my lord. Her statement was only obtained in October.
But remember, they were linked.
Yes.
The whole chain from Mr. Kutsia to the Krugers to the prosecutor.
Yes, my lord. And Tertia Kruger and Mr. Van Zyl were called. And the purpose for, or the reason for the state calling them was to corroborate the version of Mr. Kutsia. My lord, I submit that had Mr. Kutsia told the police during his first interview with them what he had included in his statement in October, there's no way the police would have just released him without taking his statement. He had vital information, very important information about this matter. They would have immediately taken his statement and followed up on the information, and would have gotten a statement from Ms. Kruger as well. But they did not, my lord, because I submit what he had said to them was not what he told us.
Is there a factual basis for that? Or
My
is
lord,
it mere speculation?
The reason why I say so is because when I had questioned Ms. Tertia Kruger, I had asked her what specifically did the witness, Mr. Kutsia, say to her. And all she had relayed to us was that in February we're going to see something like a movie scene, and the place won't be known to them. There are going to be lots of vehicles everywhere. I asked, was there anything else, my lord? That was it. There was no other information given.
Remember the context. Remember the context of Ms. Kruger. She says that it was a bit much. She called her husband, and knowing that their neighbor, with an open plot in between, is in fact working in law. Turns out he's the control prosecutor at Vredenburg. And by then, the prosecutor was already involved with coordinating certain things with the investigating team. And that was the very same day that they were going to clamp down. So having regard to all of that in a context, is that not the reason why no statements are being taken now? Because remember Mr. Van Zyl's evidence is what he told me was already known to me. He already knew at the time that targets of the investigation, or at least the mother was a target of the investigation.
Yes, my lord. Even that
No, I
being the case.
I understand the delay in taking a statement, but can one now just jump to the conclusion it's because he didn't tell them everything? Because remember, there were lots of activity at that stage.
Yes, my lord. And there is a likelihood that whatever he may have relayed to them at that point meant nothing to the investigation. And as time had passed, and he heard more about it, and he then relayed what he heard.
Something that I considered in thinking it through at the time when looking at the timeline is that when he reported it was that Wednesday the 6th. By then, the 3 accused were already in custody.
Yes, my lord.
And Mr. Van Zyl knew about the appearance the next day because he said he was coordinating with his colleagues in Cape Town about the appearance. So where does that take us?
We're still in the same place, my lord. As I submit, at that point, it was only that very little that he knew, which he had relayed to the police. And that is why they may have not even bothered taking a statement. If he had known all of these things at that point, the police would have recorded his statement. Because they were already in custody, how would he have known?
But the crux of the matter was the gist of what he said, that he was told that this was going to happen.
Yes, my lord.
And that refers back to the August
2020.
morning conversation between him and Ms. Smith.
Yes, my lord, to elaborate or to go further on that, the court would recall that Tasha Kruger informed us that as soon as Mr. Coetzee started relaying the story to her, she stopped him immediately and told him to wait, and then she called her husband and he explained to them everything which he knew about the matter. And even after that being said, she still said it. He only said it's going to be like a movie scene.
Are you suggesting that I should have found Mr. Coetzee not to be reliable enough to rely on his evidence? Or should I have rejected his evidence? If so, on what basis?
My lord, in order to answer that, my lord, even Mr. Van Zyl, all that Mr. Coetzee reported to him was that he knew accused number 3, and accused number 3 told him that something big is going to happen and it will receive a lot of publicity. That's as far as he could take it.
So the detail wasn't there, but on what basis should I not have paid any attention to his evidence and relied upon it? Because remember, you're asking for leave to appeal, and it is also trite that courts of appeal does not easily interfere with findings of credibility for various reasons, but those are known to us because you are steeped in the atmosphere of the trial, you see the witnesses, you take note of demeanor. But over and above that, and we had that debate now about Ms. Lombard's evidence, there are other objective facts that I've also mentioned in the judgment that give us some comfort of reliability. Because remember, it was common cause, also from the cross-examination, and was not disputed, that he didn't know where Ms. Smith was residing. So I utilized the observations made at the inspection in loco of the place where her house was situated. In his description of what she told him and showing the blue house, so there's some reliability issue. And it was easy. Again, he comes up with this version, says this is what happened, and then he draws it through to what happened at the prayer meeting on the 3rd of March, the clothing, income, confirming his observation of the clothing. You have the TikToker and those videos, etc., etc. So that is a lot of small little feathers, as I've said in the judgment. Now, on what basis do you suggest that I misdirected myself that will warrant the interference of a court on appeal on those findings?
My lord, as I've already submitted, there is a likelihood that he could have added information which you only received or heard about by
how remote is that likelihood?
My lord,
Or rather, let me use the terms in the act and the test. How reasonable would it be to reach that conclusion on inferential reason?
My Lord, based on the attention that this matter received, and it was spoken of all over, my Lord, based on that alone, even if he chose not to, he most probably would have heard something about it. My Lord. Based on that, I submit that there's a likelihood another court.
And then he came to implant himself for his moment of fame.
It's a possible, my Lord. Another court could come to that
Anything
conclusion.
is possible.
Yes, my Lord.
The question is, courts don't speculate. You look at the facts, and yes, well, one look at it carefully, and one look at that possibility in the back of your mind, in your processing of the evidence. But then you have these snippets of corroboration or warranties of reliability. And I've mentioned but one. And it is not as if it was denied or disputed that they knew each other, and in the context as to from where, at the funeral, way back in 2016. Okay, so I couldn't follow the hearsay point in your notice. Of course, your notice is drafted as one is used to these notices. So you throw the net wide to leave you room to argue into that, and it's to the point. But you just make a general proposition by saying the court had erred in accepting hearsay evidence as none of the exceptions to the rule are applicable. Now, there's only one aspect, I think, where that could be applicable.
Well, Lord,
Mr. Kutsia's evidence.
Not only him, my Lord, it was in respect of the evidence led by Ms. Mbambo.
Yeah. Now, remember, I described the process. So I start, and I say in the opening paragraphs of the judgment, I say, I'm going to start at an earlier point than what the state argued. So now I'm going back to 2016, the first encounter, and that it was Ms. Mbambu's predecessor who dealt with the file. And what she testified about is from the file content. But there's nothing to gainsay it. No dispute about this. Because when it was presented, and I suspect, except for the small nuances that you had put to her, it's common cause that she had attended there, or her grandmother attended there initially, and then there were these other interactions and interventions, and the 2018 interventions, and that's where, on my timeline, which was different to what the party suggested in the ultimate judgment, that's why I introduced Ms. Andrews. And that was common cause. So all of that was common cause. So it was not seriously disputed. Nothing turned on that narrative that could prejudice Ms. Smith. That's what I found. So I applied Section 3 of the General Law Amendment, or the Evidence Amendment Act, which creates that opportunity for the admissibility of the evidence. But was that even necessary, or would it be fatal if it was inadmissible hearsay evidence, because Ms. Andrews gave direct testimony to that effect, more particularly the 2018 intervention. So even if I was wrong, which I suggest there are no grounds, unless you can convince me otherwise, what effect will this have on the Court of Appeal coming to a different conclusion on the inferences drawn from that evidence?
My Lord, it would have an impact if those were some of the factors which the court considered in determining the guilt of the accused.
Because even though there were the indications in the report of Ms. Mbambu's predecessor, the so-called hearsay evidence, it relates to the possibility of the Andrews adoption. One. I also utilized that to deal with the relationship between Ms. Andrews and Smith, to draw inferences on the conduct of your client when she stayed over at Ms. Andrews' house after the disappearance. Remember that the eating and sleeping issue, and the conduct when the interviews took place and so forth. So I used that, which became common cause, not the contents of the file, the fact of the relationship between Natasha Andrews and Smith, to rely on her opinion of the conduct. And then I used the conduct against your client to say this conduct would not have been expected. She didn't act like a mother who had just lost a child. And Ms. Andrews would have known better because she knew both mother and child.
I take the court's point, my Lord.
Yes. So then you deal with the inferences drawn.
Yes, my Lord.
And what do you say about that?
My Lord,
This is going to come into play again later today when I deal with Ms. Lombard.
yes, my Lord.
Because that persistent drug use, and to the extent they did, you say I should have paid more attention to that in evaluating
My
the
Lord,
circumstances.
it should be borne in mind that even the 204 witness, Ms. Laurentia Lombard, before she testified, she was already a regular drug user for about 16 years.
Yeah. And so was your client.
Yes, my Lord.
Because we know that in 2016 already, that's when she was on the walkabouts, and the grandmother didn't know where she was. It was already reported that she was a regular drug user then, and we know in 2018 she was institutionalized. And that also comes from the file contents, but it was common cause at the end of the day.
Yes, my Lord.
And the evidence about the drug use and the frequency thereof, that was also common cause.
And I submit that the regular use of these substances yours can alter your mental faculties or the way you perceive and react to certain things. And I submit that that's one of the factors that the court should have considered carefully in determining or looking at the behavior of the accused.
Now, let's just pause there for a moment. I considered the conduct and the demeanor as part of the circumstantial compact. Now, yes, one can understand that the substances, and more particularly the one that they were using regularly, has serious long-term effects, and it might affect your behavior. Now, the one issue that I dealt with is this My child made me famous. That portion. Right. Sabola, separate occasion. Lombard, Friedenberg, 25th. Very tapping. Now remember, it was suggested that your client didn't use substances after the disappearance. But let's accept that's not true. Let's accept the really true. Then the morning of the 4th, the morning of the 2nd, right? The green dress. Day. Same thing. 3 occasions. Now that's not, she was well groomed on that morning of the 2nd as well. It was a consistent refrain. Then you take the day in between the arrest and the 2nd. That's the day of the prayer meeting. Now you see different images of the pictures and the videos that were handed in. And then you have the dancing beyond the stage, the bottom there. And then you see close-ups of her at the time when she's standing with her hands open and whatever they want to call that, whether it was the rosary or some other beads. Do we attribute that to the influence of the mood-altering or mind-altering drugs?
My Lord, as indicated, not everyone is the same, my Lord.
But those are the factors, some of them, in fact all of these and others that I took into account.
My Lord, I submit it would be very difficult for us to make a call on what effect the drugs may have had on her or how she reacted to what was going on at the time, my Lord.
Now, that was clearly a line that the prosecution punted from day one, right through on the evidence. Whether we were paying attention to it, I'm talking about myself because I thought I knew where they were going with this. But I just thought that at the time, later all the pieces came together. I dealt extensively yesterday with Dubai about when is there a duty to at least challenge what is put up as circumstantial evidence. We dealt at the trial court with, and we honed in on the dictum in Busak. But of course, as I pointed out to Ms. Nkabai yesterday, in Tandwa, that was decided after the Busak case, where the SCA actually went a little bit further on that principle. What do I make of that thing? Remember, you want me to discard these inferences, not to rely on them too heavily. And yes, one shouldn't speculate. And I didn't deal with it at the trial, in the judgment. But there was nothing said about that from the defense side either.
My Lord, all I can say to that is that the inferences drawn are not the only reasonable inferences that could be drawn, and that's the ground on which I am proceeding on in this matter, my lord. Considering the fact that there was the use of drugs, and it was put from my side, although it was not really evidence, my lord, that accused number 3 was taking sleeping medication at the time as well. It was put to the witnesses by myself.
That was with
Yes.
Miss Andrews. That's why she was sleeping like a baby.
Yes, my lord.
All right, so we covered that. Now we turn to maybe a bit more interesting aspect, because Ms. Ntabay also referred to the charge itself earlier today. Because under 1.7 you deal with the interpretation of the statutory offence. So that's the human trafficking charge.
Yes, ma'am.
Where do you say I erred in that regard?
My lord, shortly, it is that the court found that the view of the American standards is applicable or suitable in this circumstance or in this matter, and that because the victim was a child, that not all the elements needed to be proved.
Well, I didn't rely on the American standard. What I did was I referred to the Griffiths-Nasana case in the Eastern Cape, and the judgment there of Hussein. And I deliberately didn't delve into the detail of it, because, as you know, it was almost an extempore judgment. It was overnight. And in the manner I chose to structure the judgment was rather as a story than as a legal expose of all the principles and so forth. So I relied on the reasoning by Hussein in that matter, and I said, I've got the judgment here, I'm not going to go to it now. I'm talking about now. That he analyzed everything, and he came to that conclusion, and I agree with that. So when it relates to a child, but that's also in line with the international standard. That's as far as I've gone. Now, unless, of course, you can suggest to me that there's anything else here, authorities that would differ on that score in the interpretation.
My lord, I do
I
not
would
have
ask
any
you, I would ask you
authority
then
in
to motivate why it shouldn't be so.
My lord, I would say
Because
so.
then now there would be a reasonable prospect of another court coming to a different conclusion.
Yes, my lord, the principles of the interpretation of statutes, they become general principles which are used in order to interpret statutory offences, my lord. And according to these principles, the legislature would not have created an offence with certain elements if it deemed it unnecessary, or if it was not necessary for all the elements to be proved. Those elements would not form part of the offence. Further to that, my lord, it's also a general principle that any act should be interpreted in a way that would favor the accused rather than prejudice the accused.
I'm just looking for the indictment because I had it here earlier. So let's look at the indictment. This is summary of substantial facts. So the So I'm looking at the act itself. Where do you say it's indicated that the means is in fact an element?
My Lord, if one looks at 4.1, before it even mentions the means, my Lord, a person who delivers, recruits, transports, transfers, harbors, or sells or exchanges.
Mm-hmm.
My Lord, the state had attempted, or the purpose of Laurentia Lombard was, or in her evidence, she testified that she saw an exchange, and which she thought was money. And that was not proven, my Lord. That's one of, I would submit that's one of the things or elements that the exchange of money or the exchange.
No, but the exchange here refers to the human being.
Yes, my Lord.
That's what it refers to.
That's for or the giving or receiving of payments, my Lord. If you look at
now the
4.1i.
Under 4.1 deals with prohibiting any person to deliver, exchange another person within or across the borders by means of, and then you have all of those set up. That's how I understand it. That's how I dealt with it. So you exchange the human being by means of abduction, kidnapping. It's gone too. So even if you would fall short under with the two different versions, you would still fall within the definition of 4.1. Because remember, we had the second charge, so that was a stopgap for the state to charge with a common law offense of kidnapping, and all that you have there is the deprivation of the freedom of movement or liberty. Take a child, whether delivered to the polo or to the Makalima's house, to go into the abyss um, that is taking away the freedom of movement or the liberty of the child. It's done intentionally. That gives you kidnapping, that brings you under 4-1 in any event. And for kidnapping, the purpose for this deprivation of liberty, freedom of movement, is not an element of the offense. We're going slightly further now than what, but because one can read into that judgment, and that's why I'm asking you, on this interpretation point, are there any authorities to the contrary of what was found in the Masana case?
I have none, no.
And even just on a reading of that case, it's a lucid exposition of the law and an analysis, and I don't think I would have been able to put it better than Hossan J as he then was put it in that case. And then it was Kader Kaistel. End of the story.
Yes,
Now, although there's a typo in your application, but I've changed it to sentence. It
Thank you,
says
madam.
"Ad
I do
conviction," but
appreciate
it's clear what you set out there.
Yes.
Now, in the event, of course, seriousness of offence, there's no question about it. You take the point on the substantial and compelling circumstances. Just broadly, which are the issues that you would say were substantial and compelling that I failed to properly take into account? Which are the factors to come to that conclusion that it indeed exists?
My Lord, the fact that she's fairly young, she is a first offender, and she had been in custody for about a year already, my Lord.
Because he quite clearly, I think it will be difficult to argue that it induces a sense of shock. Because if you close your eyes, and I tell you, anybody, it's a mother that sells a small child, the immediate response is throw away the key. So then we're not getting to the minimum sentence legislation. So let's not talk about shockingly inappropriate now. Because it wouldn't induce a sense. Now, yes, one has to determine these factors also holistically. What is the test? Starting by way back with Malchus. And of course we know about Chabalala, Machichi, and so forth, and
Well,
going
the
back at
starting
some
point,
stage,
my Lord,
and then ACA coming back again to say,
well, the starting
Be
point
careful.
would be that the punishment should fit the crime, my Lord. But
isn't that the end of the story then?
after taking into consideration any substantial or compelling or the personal circumstances of the perpetrator, my Lord, that's the purpose of our sentence procedure.
Yeah, but now having regard to the authorities on appeals and sentence, again going way back to Rex versus Lumai of 1946, I think, where the principle has been established that the Court of Appeal does not easily interfere with the sentence imposed, except in those other cases, because it's a discretion exercise. Sentence is a discretion, and especially in this particular case, where I've illustrated to you that even without the minimum sentence regime, a sentence of life imprisonment would not induce a sense of shock. How do I approach that in considering whether there are reasonable prospects that the Court of Appeal will interfere with the sentence?
My Lord, it is
very difficult, Mr. Sikh. In a case like this, it's very difficult to argue on sentence.
yes. The only time a court would interfere, my Lord, as correctly pointed out, is if the sentence imposed is so disproportionate. And another court may come to a different conclusion if the personal circumstances of the accused, more weight may be attached to certain personal circumstances. Those may amount to substantial and compelling circumstances that may permit the deviation from the minimum sentence. My Lord, those are my submissions. However, I just wish to add that,
would you say SCA or full court?
my Lord, full court would be something. There's no actual preference. My Lord, based on the evidence and everything that has been presented, it is my submission that there is a likelihood that another court would come to another decision. At most, the evidence before us now, even if one has to accept the evidence of Mr. Stephen Kutsia, I submit that as we are now, at most, the evidence against accused number 3 merely indicates a suspicion as to her involvement or that she may have committed any offense. But when it comes to proof beyond a reasonable doubt, I feel the state has fell short. Thank you, my Lord.
Who's going to field? I think let's first deal with the 204.
Thank you, my Lord.
Who's going to argue that? Are you going to argue it?
Yes, my Lord, I will be doing the arguments for both.
I take it you align yourself with Mr. Van Tonders.
I do, my Lord. That's why I did receive the email, and I did respond to the email, and I did send both the cases. I attached it to the email. So those were the only 2 cases that I would like to refer the court to, and for the simple reason that the Kyler decision was the first one in which the court has actually dealt with this inquiry, describing the process to follow, setting up the stages, and exactly saying that this is then the 3rd phase where we are in now. Sure.
It's a bit close.
It is. It really is, my Lord.
Let's flow with the punches. Hopefully it doesn't happen every day that we have all these cameras in court.
As the court pleases, my Lord.
I was reflecting on it last night, and there are those other factors that is mentioned, especially in that article by Theolopoulos.
Yes.
And it seems to me that it goes much further. Remember Opperman mentioned a few in the Taylor judgment.
Yes.
It seems to me that in the comparative studies that's been done, in the whole idea of granting indemnity to a co-conspirator who then agrees to assist the prosecution in prosecuting the crime successfully, that courts in other jurisdictions are taking into account a few other factors that I just want to dwell on with you as the prosecution. because although I will extend the reasons this afternoon, I'm sure it's going to find its way into SAFI.
Yes.
And it will be used by other courts.
Indeed.
When one look at the evidence of Ms. Lombard, now let's start at what the state would have had available against her. It was a statement to Captain Salier, and that was about it. That was about it. Now, what did she do? What is her role? Because it seems to me, in evaluating the procedure for considering whether indemnity should be granted, if these other factors are applicable, you have to look at the participation, the level of participation of the witness.
Indeed, Mother. Which?
And I'm going to get to that now, for the following reasons. And I noted yesterday that it's transactional. There's a deal made.
It is.
I will assist you, even though I might be guilty of an offense. And yes, the court has to consider the honesty and frankness of answers given. But of course, the court must also be careful not for this system that serves a good purpose to be abused.
Yes.
So in that regard, the level of participation must be taken into account.
Definitely.
So what did Ms. Lombard do? She didn't partake in the kidnapping physically.
No.
She performed no positive acts in relation to the crimes. At most, she made herself guilty of being an accessory.
Being aware of the...
An accessory only after the fact, because not reporting pre-commission, that's not making you an accessory. That's not making you a participant. The fact that you... So her sin and crime is by keeping quiet and hiding the actions and then assisting in coming up.
Yes.
That's in a nutshell.
Yes, exactly, my Lord. And therefore, when it comes to considering whether to offer immunity to a person or indemnity to a person, and to consider whether such a witness, such an accused at that stage, should be considered to be a witness, that's one of the very important aspects that we as the state take into account, the role that this specific accomplice played in the whole commissioning of the offence. And then one has to weigh it up. So, do I need to persist with this prosecution, or do I need your testimony in order to actually address the crime and the most important role player in the crime? And with respect, my Lord, yesterday you posed the question to Mr. Van Tonder, and would the state have succeeded with the prosecution barring Ms. Lombard's evidence against Ms. Smith, accused number 3? My Lord, that was why there was a need to make that call. And that is why in the Kyler decision, and it specifically deals with the relationship between the state and a Section 204 witness. And it is also then in the Makala decision, once again, it's repeated. The importance of this process, especially to address more serious crimes, like organized crime, like trafficking in persons. There's a need for this process. But there are safeguards in place. The state can never grant indemnity to any witness. It's the decision of the court. That is so.
And why the Act, it seems, use the word must,
Yes.
is to honour the
Indeed,
honour the deal,
indeed, my lord.
subject to compliance.
But not to hold the court ransom to say it must. It's the court's subjective test
No.
to determine that. But added to that, and that's the one thing that Mr. Van Tonder did not deal with, added to that, there's then that extra little bit of protection included in Section 204 that says, if the court does not grant the indemnity, the state cannot use any of that evidence against her in a following prosecution. It's pro non scripto. We can't go there, except if there's, of course, perjury, which is something quite different that's not applicable in this case.
Because by agreeing to testify, you forego that fundamental right against self-incrimination.
Indeed, my lord, indeed. And usually when one deals with a 204, and the criticism against a 204 witness, one deals with a person who does not want to accept their own responsibility and the role played and tries to exculpate. And I submit with respect that we never had that in this case. And contrary to usual 204 witnesses, in fact, she went back and said, what I said to Captain Silhier about Boeta accompanying on that Sunday to the polo, that was wrong. Boeta never went. So she actually exculpates one of the accused instead of adding on and trying to make it more serious or to the other side.
What is the personal circumstances and the conditions that Ms. Lombard was under at the time?
Yes.
What role does that play in my consideration?
A huge role, my lord. I submit with respect. If one considers, and that's why it was also mentioned in Kyler and confirmed, that when the court looks at her testimony, the court has to also, and when we look at whether the questions were answered frankly and honestly, one has to look at the circumstances under which she was at the time. Now, in my address on before judgment, we did deal with the different documents and the contradictions and everything that is expected of a 204 witness. We all know disclosure is a gradual process, even for a 204 witness. They don't immediately come out with everything from the start. As they grow in confidence and as they understand that I have this carrot that I might get indemnity, they tell the truth and they disclose more. But now we're dealing with her under her circumstances. My lord, and I'm saying this with the greatest of respect, uneducated person, a person who has been suffering with prolonged drug addiction, foreign environment, according to her own evidence, first time that she's questioned by the police, very first time that she's arrested. She didn't even know what arrest means and what the difference between arrested and charged is. She referred to the salikis, police salikis, as a reason why she didn't understand that she was arrested. She did not understand the environment, that is so. Added to that, it's this case with cameras everywhere, which must add to her tension. And the court must take that into account. I agree with Mr. Van Tonder. A witness stand is a very difficult place to be in, and it can become a very lonely place. And I think for Ms. Lombard, it was even more so, because she knew that everybody was watching her. Everybody was testing her. And
how many days did she spend in the witness stand?
Indeed, my lord.
How many days?
I'll have to guess. I think it was 5 or 6. I haven't gone back to see exactly how many days. I'm estimating it must have been 5 or 6. It could even have been
I'm
more.
estimating more, but for some other reason my other books are not placed before me.
It might be more, my lord. I can go and count the days, and I will be able to.
It was over a prolonged period.
It was definitely over a prolonged period. And the cross-examination, with all due respect, my lord, was intense. And she was taken to task, even as to her religion and her faith and how she was brought up. Everything personal was taken up with her. And she had to answer to all of those questions. And I submit with respect, my lord, if one looks at the Kylie decision in which indemnity was not granted, the court there in their judgment explains that some of the questions were answered truthfully, and although he accepted the evidence in order to convict the other accused, he didn't grant indemnity because some of the questions... I'm sorry, if the judge was this she, my apologies. She did not grant indemnity because some of the questions were either lies answered by lies, untruths, some of the questions were not answered, and some of the questions she refused to answer.
And the role played by the witness was great.
Yes.
Big.
Yes.
He just took a chance of trying to get out of it.
Indeed, my lord. No, indeed. One tends to ask the question, so why was this the 204? Upon reading the judgment. But in our case, my lord, with respect, none of the defense has showed us to anything that Miss Lombard of material, of substance, lied. Or different to today.
So let's fast forward that point, because is the crux not, because it's a process, and just human nature, one can expect that you will have lies in the run-up. You will have partial disclosures, and then ultimately I'm talking about 11/16 October. Now you have, as they say in Afrikaans, a ontboezeming coming out with everything.
Yes.
Now the witness testifies.
Yes.
So one can expect the witness will be confronted with everything that went before.
Yes.
What does the Act require of the court? What do you consider as a court? Now, looking at it subjectively.
Yes.
So now the whole issue of how we are trained as lawyers is put on the back burner. Now we have to look at this. What do you compare to determine whether the witness answered all questions frankly and honestly put to her in this case?
My lord, I submit with respect her oral testimony. That then is the important aspect. And as in Kyler set out, the whole of her testimony, not only certain issues, certain aspects, as has also been suggested by some of my colleagues from the defense. The court needs to consider her evidence in totality, her evidence, because this is a subjective test, and the court must be satisfied that subjectively viewing her testimony, when she answered the questions, she did so frankly and honestly. She believed that what I am answering is the truth. I am telling the truth now. Whether it's right or wrong, that's not the test. The test is whether when she answered that, she answered it frankly, she came out with the answer, and she believed that it was true. And
now,
it's for the court to then decide it.
Now, I'm well aware that whichever way I go, there will be disagreement.
Yes.
Some people will feel that you should,
Yes.
others will say you shouldn't. I don't care about that. I've got a job to do.
Yes.
So, if you expect, if the test is for the presiding court, the presiding judge or the presiding judicial officer, if it's in the lower courts, have to subjectively come to that conclusion, would it be correct to say it's your assessment of that witness
Yes.
before you,
Yes.
and you don't necessarily pay too much attention to the extracurricular stuff that went on?
Indeed, indeed, my lord. That is how I understand the position. That's how I understand as the test is set out in the Kyler decision, and specifically paragraphs 40 to 46 dealing therewith. And it was also in the Makala decision, 42 and 43, specifically dealing with that test. What exactly? The Makala decision repeated what in the Kyler decision was said as what is frankly and honestly how it is supposed to be interpreted. It's a judicial discretion that the presiding officer must form based on the oral testimony of that witness.
And the offences would be the main count here and any competent verdicts on that, and the second count.
Yes,
that's
my
what
lord.
I cautioned on.
Yes, my lord. And as I requested the court to caution her on the two counts, as well as the alternative counts, those are the counts that I request the court to indemnify her on. And my lord, just to add that very last little bit, even if, and specifically this is, and I say this with the greatest of respect, it's also in the Makala decision and the Kyler decision set out, but even if the court were to grant indemnity, and so she may not, or even if the court refuses to grant, if the court refuses to grant indemnity and say, I'm not satisfied.
The easy way
Even
out.
then-
The easy way out for me. It would be the easy way. To refuse indemnity.
Yes.
And to say, well, it's in any event in the discretion of the state to decide whether to prosecute or not.
Indeed, my lord.
I know what the evidence would be, and they may not succeed, so I'll cop out. But that would be wrong.
Yes. Yes.
Because I'm required to make an order, and I'm required to make an order that I'm comfortable with, in
Indeed.
my conscience and nobody else's.
Indeed, my lord, a judicial discretion absolutely must be exercised. Indeed.
Right, now let's deal with...
My lord, may I just one last aspect, because Ms. Mkabai dealt with it. I'm not in agreement with the argument that this inquiry must be done before sentence. I don't know what the basis for that is, but I'm not in agreement with that submission. My submission is, it is the safe way to accept the possibility that other evidence might come during the sentencing stage, and to do this inquiry afterwards, as it was done
I'll
in
tell you
this
what my
case.
prima facie view is. One shouldn't be prescriptive as to when.
Every case on its own.
As long as you have a proper process and an inquiry, and everybody gets the opportunity to have a fair hearing in that regard.
Indeed, my lord.
So although the process envisaged by the Act is that the prep stage, let's call it the prep stage, that's when the person now decides, I'm going to make a statement, that's done. Then it's the trial stage where the witness testifies.
Yes.
Then it's the indemnity stage,
Yes.
stage 3. Because you will find, and I know that it's suggested that it must happen after judgment.
Yes.
Some cases it might not be necessary to wait. So my prima facie view is to stay away from being prescriptive. Because it's in the discretion of the trial court to manage your trials.
But I do support, my lord, I do support the view expressed in the Kyler decision that it must be at least, or at the earliest, after judgment on the merits.
Yeah, because you will find that depending on the nature of the case.
Credibility.
But invariably where you have a 2 or 4 witness, there will be credibility issues.
Yes.
And you never know what comes out of the defense case. You can do it, how you do it in the main judgment, I find it difficult to understand how you can do that, because when do you give the witness the opportunity to be heard? Whether it's before or after sentence, that would be up to the trial court. I decided in this matter to do it after the sentence, and one of the primary reasons that I had in my mind was there was no evidence on the merits from the accused. I don't know what evidence might come out in sentence that might affect.
Yes.
And then if you grant indemnity, you've already granted indemnity. You can't change your mind.
Yes.
If you refused indemnity, you can't change your mind. So rather than have everything.
Indeed. Indeed.
All right. So let's go to the merits. Have you prepared it or not?
My Lord,
Was this a note?
I have not prepared
No,
it.
no, that's fine.
For the simple reason,
Just for the structure.
In order to keep this, to actually shorten the proceedings, I've prepared, and then yesterday I decided.
No, that's.
So I propose.
The only person that I have a note from is Mr. Van Tonder.
I propose, my Lord, in order to deal with this, I propose to deal with it by way of answering some of the aspects that the court has raised with defense counsel during their arguments. That is my proposal from this.
So let's start from the back.
stage.
I'm going to ask you a
Start from the
question.
back?
I'm going to ask you a question.
Okay. No problem.
Sentence, I take it you've got nothing to add.
No, thank you, my Lord. I think no other court could come to any other sentence. It's the appropriate sentence.
So then there were issues raised about irregularities in the trial.
My Lord, there were no applications whatsoever at any stage for any special entries to be made, despite several invitations. My Lord, there has been a number of allegations, very serious allegations, and some I take offense to, made. I submit with respect there's no factual basis for any of those allegations that were made. And in this instance, although I personally, and we as the prosecution were initially opposed to the idea of the media presence, in hindsight, it is good that we now know that we will not only have a transcribed record, we actually have it recorded.
Well, I'm sure there will be footage of my face so that the appeal court can rule whether that was
Indeed, my Lord, and hopefully everything will be, everybody would be able to see and hear everything that was said and done, and faces pulled. I've also been accused of pulling my face. So.
On a lighter note, Ms. Swanepoel, you know, one can't see your own face. So at least I will know what an angry face looked like. But I don't know whether Mr. Kalai was serious, but it's so. So then, on the interpretation, so I said I'm going to take it from the back. Mr. Signerine raised the issue on the interpretation.
Yes.
And the reason I'm starting there, because if there's a reasonable prospect on his argument, on the law and the interpretation, then we can just grant leave.
Yes. Indeed, my Lord.
But then the defense might be over-optimistic of sending it to the full court, because then one might want to have clarity because it will be the first time that,
Yes.
because we have the judgment of
Masana.
Masana, it doesn't help to have another
Yes.
decision,
Then
then the
it should
SCA
go.
can once and for all
Yes.
pronounce on it.
Yes.
I'm not saying that I'm buying the argument, but hence I want to hear you first on that. Because
Thank you, Mama.
if you're with Mr. Severine, then you can just as well stop
No.
the proceedings here and I
No,
can't believe.
no, my lord, and I think by now you know that when it comes to trafficking in persons, I have a lot to say, but he forgets that it's not only the Ngasana judgment and the international position, because that is the accepted international position. It's not only that, it's our legislation. Our legislation in Section 11 of the Pakotip Act says exactly that. It says, even if none of the means are present when we're dealing with a child victim. So our legislation makes it clear that it's not an element. We do not need to prove the second element, the means element, when we're dealing with a child victim. For a child victim, it's only the first and the last. The act, which in this instance is the selling of Joshlin, and the last element, which is for the purpose of exploitation, which this court has found to be the slavery or practices similar to slavery.
On the broader definition
In-
thereof.
Indeed, my lord. But my lord, I'll even take it one step further. Even if it had to have been necessary, by some chance, but that would be an incorrect interpretation of the law. Even if it was said it's necessary to prove means, the state has in any way proved means, because we have proved kidnapping, we have proved force, we have proved
Well,
deception.
11 specifically says that when it's a child, even if none of the means referred to in 41A, A to J has been proven, but I found abduction, which is clearly, and that's what I said in the judgment too.
So that's what I'm saying. The court has actually even found, although it's not necessary to prove the means was proved, because the court has also convicted on the kidnapping, which is one of the means in Section 4.1. So there can be no doubt about it. I respectfully disagree with my learned colleague in that regard. And this is an important issue because that specifically is the new law that's created by this decision. It's the first time that it is facts such as this, the disappearance of a child that has still not been found.
And in any event, even if you're correct, that by finding there was a kidnapping, you would in any event have satisfied, even if it was a requirement under 4.1, contravention of that provision under count 1 with us, then granting leave would be an academic point, and you don't grant leave for academic purposes.
Indeed, my lord, we have passed that era of just granting leave just because we have an appealable case, or to that safeguard that a next court would just confirm, or a next court can correct something that was wrong in my first decision. We have passed that. The test now is there must be a reasonable prospect of success, and only then this court should grant leave to appeal. And not.
Then let's deal with the evidence, because you can deal with that holistically, and I'm sure you're prepared on that.
Yeah.
And that's where the proof beyond reasonable doubt and all of those come in. We don't have to go into the individual issues.
I don't intend to go into the individual issues. My lord, just one aspect that I just want to, because you've taken me from the back, so I'm just still with Mr. Sivner. And more specifically, there's reference to the applicant. The court failed to take into, I'm reading from paragraph 1.6. The court on page 3. The court failed to take into consideration that the applicant was taking sleeping medication after she learned about the disappearance of her child Joshlin. Submitted that the use of drugs together with, I think it should be with, the sleeping medication could have greatly impacted the behavior and reaction of the applicant. My Lord, the only evidence to this aspect was the evidence of Kelly Zegers, where she testified and said she had taken one tablet, the one tablet that Natasha Andrews had acquired when they went to the clinic. There was one tablet, and the rest of the tablets are all still with her, Kelly Zegers, not with the accused. So there's no evidence at all to make this averment. And coupled with that, my Lord, in argument raised now, Mr. Sivnarine argues that the effect of the drugs that could have impacted her reactions and could have impaired her reactions and caused her not to. We must remember, the evidence also says when Captain Lombard confronted her and said on that 25th, they say, I must ask you, she immediately reacted to that by saying, hoe kan Boeta dit aan my doen, ek is lief vir hom. So there's no impairment of any decisions or any effect. She's lucid there immediately and reacts without any problem. And that is but one example that I can refer to. My Lord, with regards to the argument of Mr. Kutse's evidence, there is no ground to argue that that was a recent fabrication whatsoever. This has been dealt with in my heads of argument. The evidence of Mrs. Creer and Mr. Myself clearly rules that out. There's no ground to argue that he would have invitedly taken up the opportunity to a minute of fame in court to testify about that. And no other court would come to any other finding in that regard. I think those were the only aspects. If I may now just go to Mr. Harms's submissions. Mr. Harms's submission with regards to the injuries of accused number 1 and that that those injuries were sustained afterwards and could only have been there. My Lord, once again, there's no evidence. This court rejected the evidence of accused number 1 during the trial within a trial. And there was no other evidence given in the main trial. So the only evidence that we have is that at that time he had a blue eye. That was the evidence of Lombard and Fortuin. There's no other evidence to the contrary. The defense witness does not, with respect, take it any further. Mr. Fortuin notes extra injuries on the Sunday, on the Sunday when he does the warning statement or in any event. The day when he takes the warning statement of the accused. And he notes extra injuries. Now why would, if the police are responsible for these injuries, would he be noting extra injuries that he himself can see? If we look at the probabilities, there's no chance that any other court would come to any other finding. There was nothing wrong in the finding of rejecting both accused 1 and 2 as poor witnesses and accepting the evidence of the state
How
and
can you say
admitting
that
those
about, how
documents.
can you say they were poor witnesses?
My Lord, that is my submission. Respectfully, that both accused 1 and 2 were poor witnesses.
Being conservative.
You're being polite.
I'm very polite. I'm very polite. I'm very polite. It's very important that evidence should not be looked at in piecemeal, and this is what Mr. Harms's argument was, that he elevates this defense witness only. The court cannot do that, and no other court can do that. One has to look at the evidence in a whole. That submission about the doctor being in the presence of the police for 24 hours for the whole day, I don't know where that comes from. That was not the evidence. And it was the doctor's evidence that the injuries were at least older than 24 hours, contrary to what was argued being fresh injuries. Same with the argument about Polo and Makalimo. My Lord, the court made the finding that it's not even necessary to go there. The selling, the agreement to sell Joshlin had in fact taken place. Joshlin was delivered. To whom, doesn't take it any further. It doesn't matter to whom she was delivered. She was sold. That's the end of what needed to be proved.
It doesn't matter for purposes of the conviction.
Yes.
Because it sounds very insensitive.
If
one just says it doesn't matter. Just for context, on our argument, we're only dealing with the conviction.
I'm sorry, my Lord. Of course, that's said with the greatest of respect. I did not.
Because one still hopes that somebody will say something.
Yes, my Lord. I mean, that's our prayer. Is that somebody will say something? Definitely. There was no evidence, and the defense, instead of not only not calling their own clients, they also did not call any of these defense witnesses, possible defense witnesses. All state witnesses were made available, and I include Makalima in that. And the test is whether there's a reasonable prospect of success, whether in this instance there is none. As far as Ms. Mkabai's submission goes, my Lord, the whole argument about the disclosure of documents from the state's side, my Lord, I submit that there was no piecemeal disclosure, as it was said. There was no special...
You don't have to go into detail on that.
Thank you, my Lord.
Because, remember, I took over the case management of the case.
Thank you, my Lord. Thank you, my Lord.
And I personally managed the case. And we made special arrangements for purposes of preparation.
Indeed, my
And
Lord.
it was never raised at the trial. So how can the Court of Appeal rule on something that was not even considered in the trial court?
Indeed, my Lord. Thank you very much. There was no arrest as claimed at 2 o'clock on that day. There's no evidence to that effect. In fact, not even the accused's evidence when he testified in the trial within a trial even him said, they never introduced themselves, they never told me why, they never arrested me, they never informed me. So there is no ground for this whole argument about the arrest. Coupled with that, the argument about the 48 hours, my lord, that's also incorrect. The only evidence before the court
evidence was rejected on that road, and
yes.
we.
I'm taking it the next step now, my lord. The evidence was that they were arrested at 4 o'clock on the 5th of March. So
in the cars.
Yes. Well, my lord.
Well, on the one hand, it's been argued, but all those forms is 4 o'clock in the morning. Yeah, and then.
Yeah. My lord, I just want to, just for completeness sake, so that's 4 o'clock on the 5th of March. That 4 o'clock, 48 hours, Section 50 is very clear about this, that 48 hours would then expire outside of court hours. On 4 o'clock the morning of the 7th, they appeared immediately on the 7th in court. There's no argument, and it was never raised whatsoever, and there's nothing wrong in the arrest, detention, or the appearance of the accused in court. The doctors, I submit respectfully, did not support the evidence and the allegations of the torture. As said, the doctors said they would have expected much more and severe injuries, so that's an incorrect submission that was made. With regards to the argument about Captain Siakwi paging through documents and making notes, there's no evidence whatsoever that any other notes were made except for that document, and the real evidence, the video, is the strongest evidence which clearly correlates between what was said and what was noted down and what was not noted down.
He wrote less than what was said.
Exactly, my lord. So, and yeah, not even, and so that criticism is completely uncalled for. My lord, with regards to the whole argument between admissions and confessions, the state submitted that both the documents were confessions.
But it submitted. The primary submission that we took quite a while on was that Mr. Kabai said procedurally it was dealt with incorrectly by the court, in that I should have looked at the statements and then made a decision whether they were admissions or confessions, and then decide which process.
My lord, I submit with respect that that is incorrect, and I have never come across that whatsoever. There might be the judicial peak if it's absolutely necessary. That is not the argument here. The argument at this stage is, and this is my submission, we said it's a confession and not only admissions. We therefore actually went to the higher onus to prove, because we then say, so let's go 217 and prove all of the requirements for a confession, which we did. So, and I still submit that those were confessions and there was no error, but if there's an error, it was an error on the side of caution, and a trial within a trial was held in order to rule on the admissibility, and there's no irregularity whatsoever in any of that process. There is, I submit with respect, no factual basis. There was no facts that Captain Lombard agreed to the nature of the injuries as was submitted, or that Fortuin noted the injuries. Fortuin noted the injuries of accused number 1, not of 2. I still submit that accused number 2 did not sleep, and his name was not repeatedly called to him, and the video would show that, and in fact he verbalized much more than what was noted down. And the transcript of that video would clearly show that. There's absolutely no basis for this allegation of manipulation of the form by Captain Siekwe, the confession. As was argued, there's no factual basis for that whatsoever. And Dr. Zweni was not in the presence of the police. There's also no evidence whatsoever to support
Dr.
that.
Zimri.
Dr. Zimri. The 48 hours I have dealt with. Yes, there were no requests for special entries to be made. There's no factual basis for any of the allegations of collusion or coaching or any irregularities in this instance. Oh, and just for record purposes, my Lord, I want it to be stated clear. It is so that the court invited parties to submit whatever documents to Mr. Peterson or the Department of Social Development for the purpose of compiling probation officer's report. I want to state it unequivocally. The state did not provide any documents or any information whatsoever to Mr. Peterson or DSD. That includes the state's heads of arguments. No documents whatsoever or input was given. My Lord, I submit, considering everything, none of the grounds that were raised or any of the arguments submitted constitutes any reasonable prospect of success on appeal, either on conviction or on sentence. And I urge this court to dismiss all of the applications for leave to appeal and to grant indemnity to Ms. Yombo. If the court doesn't want to hear me on anything else, I will rest.
Mr. Harms, anything to reply?
My Lord, I
don't know whether you have a microphone. No, it should pick it up.
I'm sure I'll pick up. I'll raise my voice. My Lord, but no, I'm not going to reply. I consider it seriously. I can go to Erasmus, to the court, Supreme Court. I can refer to other case law, but I leave it in the hands of the court. The court is well aware of the duty that's on the court to honestly and objectively consider the submissions and the evidence that was laid and the decision that was taken by the court, whether that will amount to the possibility of a truly reasonable success. As far as the accused number one, the police is concerned, it was made clear that it is purely based on the admissibility of the executorial statement, and that if we submitted that, another court would come to a different decision that that would have been or should have been inadmissible, found inadmissible on the basis that there is an onus on the state to prove beyond reasonable doubt that he was not injured. It's not on the accused. Thank you.
Goodbye.
Thank you, my Lord. My submissions, my Lord, remain. I have nothing to add.
Thank you.
There are reasonable grounds and compelling grounds.
Yeah.
That leave for appeal must be granted. As court pleases.
Thanks, Lord. Just one aspect. My learned friend for the state indicated that with regard to the evidence of the section 204, that the evidence should be looked at holistically, or her testimony holistically rather than compartmentalized manner. That having been said, if you have to look at it holistically, it's clear that she was a dishonest witness and unreliable. That's my submission. Thank you, Madam.
It's 2 o'clock. Take half an hour. I'm going to come back at 2:30. Just a question, Ms. Lombard. Kan jy Engels verstaan? So as ek verduidelik in Engels, sal jy dit kan volg of moet ons probeer om 'n tolk te kry? Wel, try, okay. No, 2:30, I'm sure the criminal courts will be done some of it. Ons gaan probeer om 'n tolk te kry. Maar as ons nie 'n tolk kry nie, dan gaan ek vir u probeer in so eenvoudige taal as moontlik verduidelik. Nee. En ek sal self dan so hier en daar vir u vertaal of agterna vir u vertaal wat ek gesê het. Net verduidelik wat ek gesê het. Sal dit u pas? Maar ons gaan ons bes te probeer om 'n tolk te kry.
My lord, my apologies, my lord. I wanted to say something.
Yes.
My humble apologies for being late on the second process, my lord.
It's fine.
Thank you.
appeal is limited to the admissibility of the extracurricular statement that was admitted after the trial within the trial. Ms. Mkabai, on behalf of Mr. Van Ryn, raised various issues relating to as the parties are at idiom that there is no compelling reason why the appeal should be granted. It is rather pegged on whether there is a reasonable prospect of success. The reason for the findings on both the merits and the sentence were fully set out in the reasons handed down on the dates I stipulated above. I need not add thereto. Insofar as it relates to the sentence, it is clear that it can never be said that a sentence of life imprisonment, in particular on count 1, on the human trafficking of a child, where life imprisonment is imposed, where persons have shown no remorse, would be shockingly inappropriate. And for that reason, leave on the sentence should be refused. Turning to the merits and the attack on that, this court made factual findings, draw inferences from circumstantial evidence, and had the benefit of observing the witnesses upon which I made credibility findings. There was nothing indicated to me, in my view, that would indicate that there is a reasonable prospect of success on appeal. Consequently, the applications for leave to appeal, insofar as it relates to Mr. Apollos on the conviction, is refused. And insofar as it relates to Mr. Van Rijn and Ms. Smith, it is similarly refused. Thank you. I shall now turn to the issue of the Section 204 witness. Ms. Lombard, you must listen attentively as to what I'm going to say, as it has certain consequences. I explained to you before you started your testimony in this matter what the law says about a Section 204 witness. So that included the first stage of your preparation, your right to legal representation, and the process that was going to be followed in court. You explained that in the event that you comply with preconditions in the Act, that you will be entitled to be granted an indemnity for prosecution on the charges that I've mentioned to you. Those charges were, and I'm going to summarize it for you, a count of human trafficking, with various alternatives, and then a second charge of kidnapping. I promised you that in the event that I find that you answer questions frankly and honestly, that is put to you, that you will be discharged from prosecution in respect of those offences. So now the time has come where I will tell you what my view is. Because as I understand the law to be, it is a decision that the trial court must make. And because it is a subjective test, it depends on me and how I feel about it. Properly applying the legal principles. But it is ultimately the decision of the court having regard to various factors that I'm going to try and explain to you. Now before I get that, I need to make a few comments. It was raised in the last 2 days that I should have dealt with your application much earlier. Meaning, immediately after I had given judgment on the 3 persons that were accused. You were not present at the time. But also, you might or might not be aware that the trial had taken a certain route and it was litigated in a particular way. After you had testified and you left the court precinct to wherever you had gone, a lot of other evidence was presented. And when a court looks at the evidence, you look at the evidence as a whole. Also, in the main trial, the 3 accused persons did not testify. From my experience, it often happens that when it comes to the sentence stage, then new evidence arises, particularly where the accused did not testify in the main trial. Hence, I decided to deal with this issue only after sentence. As you heard yesterday, I was not inclined to deal with your application unless you have legal representation. And that is why Mr. Van Tonder argued on your behalf yesterday, for which this court is indebted to you. I will not today repeat all the arguments. You would have realized that in the process of the argument, I was referred to a number of court cases. I will not repeat them to you. I'm well aware from the evidence that was presented, your level of education and your social standing in life. And I want you to understand what it is about. Now, this process where a person can testify for the state, having been a participant in the commission of a crime, serves an important purpose in the criminal justice system. It gives the opportunity for the state to successfully prosecute participants in a crime with the assistance of a co-accused. It is primarily a trade-off and a deal that is being made. It is in order for the state to achieve their objective of getting a conviction, which they would have had difficulty and often unable to do but for the assistance of the witness. And for the witness's side, the benefit is that you might be indemnified by helping the state. In order for the state to make that decision, various factors are taken into account. One, the seriousness of the offense. And the involvement of the particular person that would be a potential witness. You will recall that when you testified, questions were asked to you about some of the things that I'm now mentioning to you. State must decide what is the relevance and what is the importance of the witness's testimony. Coupled with that, what would be the collateral consequences? It's also important to note that through this process you were in witness protection. Because there must be a guard against any reprisals against the witness for offering their assistance to the state. It has two legs. One, the witness will come and admit complicity, and the community will see that person as but another guilty person. And secondly, where this process is most helpful, will be in organized crime cases where the life of the person becomes endangered by the co-conspirators. In their decision to come to that conclusion that the person may be used as a witness, various other factors like age and so on is taken into account. You will also realize that both with Mr. Van Tonder yesterday and Ms. Lombard today, Ms. Swanepoel today, I'm making that same mistake again because I'm speaking to you, Ms. Lombard. We engaged on the issue of what the state's ability would have been to get a conviction, especially for Ms. Smith, who was regarded as the kingpin here, if you didn't testify. So the deal I spoke of is a trade-off. Now let me explain to you how I want to approach the question of whether you have satisfied the requirements to qualify for an indemnity. A lot of criticism was raised against you. At trial, during cross-examination, and here in the last 2 days. It is expected of me that I must find my way through this cloud and the dust that's being kicked up. And in considering this question, I also want to look at it purely as a common sense approach. Often, as in your case, a person that has something to hide in the beginning does not come clean. You might lie, as you did, because you expected that 1,000 rand. It might sound little to many people. I saw your living conditions myself. I was there at your house at the inspection. I heard the evidence of your drug use and abuse over a prolonged period. R1,000 was a lot of money for you at the time. And you needed to feed your drug habit. You were so desperate that you had to go to Miss Smith often to beg for food for your children. I cannot ignore that. You left school in primary school and had a hard life. I'm glad to see that you look much better. You had no encounters with the law before. You had no understanding how to deal with authority. How much weight do I then place on your reluctance at the outset to come clean? I suggest it should not carry that much weight. I told you I was going to approach it from a common sense approach. And I spoke about this deal that you reached. It is a process. Seldom that a co-conspirator or participant in a crime come out with everything in the beginning. It took you a period of 7 months between March and October. That was your arrest, your statement to Captain Celia, and your ultimate statement that became known as the 204 statement in October of 2020. And of course we also know that prior to your arrest, your version was different. There was an agreement that nobody should mention the name of Mr. Van Ryn. Hence, Mr. Apollos and Ms. Smith didn't say anything on the 19th and 20th of February. It was you that made the first slip up from their perspective by saying he was there. Just shows the progression as you go along. We were told, and it's not evidence, but it came out in cross-examination also, of this process and to and fro between the investigating officer your advocate Van Tonder at the time, and how that statement was eventually arrived at. And how the version grew and was adapted and corrected as you go along. I'm now being asked, because of what happened before you took the witness stand, to use that to come to the finding that you were not honest with the court. I'm of the view that that approach is wrong. Up till that point that I cautioned you, you had the right not to incriminate yourself. And, as indicated, there's nothing strange about the progression to the truth. So it would be unfair to attach too much weight to what happened before the person became a witness. Having become a witness, the court will have to evaluate the evidence given. Now you will recall that I asked you a number of questions, often to the point where you would admit that either you made a mistake or that you lied in the past. But does that mean you did not answer the questions posed to you in court, frankly and honestly? Having regard to all the human frailties and the condition of the courtroom. I cannot ignore the fact that in itself, being a witness, and particularly in the High Court, confronted by heavyweight defense counsel and the intimidating atmosphere of a courtroom, that it is easy to trip up. What I can say about you, Ms. Lombard, that you owned up to your mistakes. Always. The decision I will make today will not be accepted by everyone. There will be people that will criticize me for the decision on both sides of the divide. That's not the test. I indicated to you at the outset, it is my decision of how I evaluate you as a witness that testified in this case. And in evaluating that evidence and coming to the conclusion, one should be very careful not to nitpick unnecessarily. If courts do not approach the whole system of Section 204 seriously, and to lightly refuse to grant indemnity that was promised to a witness, that might also undermine the criminal justice system in itself. On the other hand, it should not be used as a tool for people that commit criminal conduct to hide behind. Hence, the decision for the prosecution to utilize this tool and request the court to apply it must be considered carefully. Two things happen. The witness has to forego a fundamental right. And yes, there are protections in the Act that the evidence given, if the witness does not get indemnity, may not be used against that person. But it might be a little, too late. As it is the court's decision to determine the question, to my mind, the court can take into account the demeanor of the witness. Having regard to all the considerations that was so lucidly set out by my sister judge in the Free State, in the Kayla case, and confirmed by the highest court in our country, I'm of the view that you should be granted indemnity. And that indemnity should be granted for the following offences. That is a contravention of Section 4, read with all the other relevant sections of the Trafficking in Persons for the Purpose of Exploitation Act, and all the alternatives that thereto under Section 10 and its derivatives, read with 11, that you were cautioned of. Should also be indemnified on a charge of kidnapping, in respect of Joshlin Smith, and any of the competent verdicts on those offences. This decision is arrived at after consideration, in particular, your part in the offence, which is the following. You were aware that the arrangements were made and said nothing. But that's not an offence. After the incident happened, you kept quiet as to the commission of the offence and went along with the story that was told by the others. Over and above that, you played no active role in either the trafficking or the kidnapping of Joshlin. So before I conclude, Ms. Lombard, did you understand that? So you may not be prosecuted for these offences that I've indemnified you, and you will be served with a copy of the order. It will be in English, but at least it was translated to you in Afrikaans now. Good?
As the court pleases.
Thank you.
As God pleases.
Ms. Swanepoel, we will email you the order tomorrow because it's typing it up and then editing, because we need to get the indictment. Do you maybe have the indictment in electronic form?
I do.
Send it to Mr. Gross,
I will.
so that we just copy everything in.
I will.
Thank you. I'm indebted to counsel for your assistance. And my last part of this case. Nothing more for me to do. But are you going to bring evidence?
All right.
You can say so long. I'm going to adjourn in a moment. We're done. If people want to leave, they can leave. I just need to switch off my device. Court adjourned.
All right.